But so what we'll do is put that on the February 24th date, and looking like that will be one of our first set for that next trial period, which will be in March.
Okay.
All right, February 24th.
All right. Thank you, Your Honor. Good to see you.
Anything else, Mr. Hersher?
I believe that's all I have. May I be excused, Your Honor?
Yeah, that's of course. Thank you. All right, Mr. Hardy. Morning.
Ramirez, 24 CF 750, and Mr. Ramirez is present and approaching. Your Honor, we're pretty close to a resolution. Got to check on a couple of things.
30 minutes close or like a couple weeks close?
A continuance close. One issue we got to figure out.
Okay, all right.
That's correct. No objection, Judge.
All right, this case isn't too old, but it's starting to get there, so February 24th, let's see if we can get it resolved the next time around.
Thank you, Your Honor. That's all I have.
All right, thank you, Mr. Hardy. Have a good day. Let's see, Miss Dudley, is she? She was in the hallway. Okay, Mr. Rare. Morning.
Your Honor, I've got one on the docket this morning, Wesley Stancher. We've got an agreement for a plea into PTI, if I could approach with the paperwork.
Yes, sir.
Yeah.
All right, you raise your right hand, Mr. Stancher. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, and this is your William David Stancher III, and this is 24 CF 2211, is that correct?
Yes, sir.
You can
Wesley.
put your hand down, sir.
Thank you.
All right, and how old are you, Mr. Stancher?
36.
All right, did you go over this plea and sentencing agreement, which involves pretrial intervention with your lawyer?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
All right, did you have an ample chance to speak with Mr. Rare about the terms of this?
Yes, Your Honor.
Okay, I just needed an out-loud answer, thank you. And you understand this is pretrial intervention, so if you successfully complete everything, your plea would ultimately be withdrawn and your case dismissed. Do you understand
Yes, Your
that?
Honor.
All right. All right, let's see, are you under the influence of any alcohol, drugs, controlled substances, or prescription medications that would prevent you from making a good decision here for yourself today?
No, Your Honor.
Any diagnosis previously of any mental health issues or concerns that could impair your ability to make this decision?
No, Your Honor.
Are you satisfied with the work that Mr. Rare has done for you?
Yes, Your Honor.
All right. Has anyone forced, pressured, or threatened you in any way to enter this plea agreement?
No, Your Honor.
Has anyone promised you anything in return for the plea?
No, Your Honor.
Do you understand by entering the plea there won't be a trial of any kind?
Yes, Your Honor.
All right. Do you understand that you're giving up your trial rights, which are enumerated and spoken about here in this agreement that you've signed?
Yes, Your Honor.
All right. Do you have any questions about those?
No, Your Honor. Thank
All right. All right. And Mr. Stancher, how far have you gone in school?
Bachelor's degree.
Okay. Did you completely understand everything that was in the agreement that you've signed?
Yes, Your Honor.
And this is as to all counts? Okay.
Yes.
All right, so that's the written threat of harm, count 1, use of a two-way device to facilitate a felony, count 2, count 3 is misuse of the 911 system, count 4 is stalking.
Yes, Your Honor.
All right. And what is your plea, Mr. Stancher?
Plea no contest, Your Honor.
All right, I'm going to accept your no contest plea as freely, voluntarily, knowingly given. Place you on the pretrial intervention, which basically means you're entering into that program. Once you successfully complete that, as I stated, your plea would be automatically withdrawn and the case dismissed by the state. If you fail to complete the terms or otherwise violate the pretrial intervention agreement, which is separate and being filed with this sentencing agreement, then you'd be assigned a court date to come back for sentencing. Do you understand that?
Yes, Your Honor.
Do you understand that if you come back for sentencing due to a violation of the pretrial intervention, I can sentence you up to and including the maximum sentence for each of these charges?
Yes, Your Honor.
All right, which is for the count 1 is a 15-year second-degree felony. Do you understand that?
Yes, Your Honor.
All right, and then 5 years for count 2, 1 year for count 3, 1 year for count 4.
Yes, Your Honor.
Okay, doesn't mean that's what I'm going to do, but if that were to happen, I just want to make sure you understand that. All right. Do we have What are the costs as part of the pretrial intervention?
PTI contract should cover all costs and terms, Judge, and he'll
Okay.
meet with probation on the way out for his initial check-in appointment.
Okay. All right, so just so the pretrial intervention agreement calls for $40 cost of supervision, $615 court costs, 50 hours of community service, anger management within 90 days, no trespassing at the Peoria Boulevard address, no contact with Mr. Borland, but it would not be a violation to be present at children's games or events, just avoid contact with Mr. Borland and Ms. Mizell, is that right?
Yes, Your
Okay.
Honor.
All right. Yes, sir. Okay, is it not signed? You said that he has to sign it, I think it was signed.
Well, we have to instruct him.
You have to instruct him, all right, so probation will sign it?
Correct.
Okay. All right,
I believe that's all I have, Your Honor.
all right, thank you.
Thank you, Your Honor.
Make sure you talk to probation. All right, Mr. Gilbert, were you ready, or want me to pass you one more time? Okay, all right, Miss Dudley is back. And then Mr. Powell, I'll put you for next. It's
Oh, this
okay.
dude, see, I did this one.
Oh, that's good, and I'll put her on there as well.
Your Honor, the first one I have is Chase Glover.
Chase Grover
Glover,
Glover.
22 CF 1170. I have a misdemeanor plea, if I may approach.
Yes, ma'am. Okay, appreciate it. Thank you, Ms. Dudley. All right, so this is 22 CF 1170 Chase Glover. Just to kind of make sure the record's clean, counts 1 and 2 were previously dismissed by the court when Judge Gontarek did that a month or two ago.
Yes, sir.
And then count 3 would be dismissed as part of this plea, and he's pleading to count 4, resisting without violence. Is that right?
Correct, Your Honor.
Okay, let me take a look at this.
I've just filed on Kobe Hart. Is he here? Yep. Okay.
All right, so I'm accepting the written plea agreement to the misdemeanor charge of resisting without calls for an adjudication of guilt, $270 in court costs, time served. He has 90 days from today to pay those costs, Ms. Dudley. Thank you. Do you have anything else, Ms. Dudley?
I do, Your Honor. Mr. Hart is being transported, so I have Cameron Moffitt in 24 CF 2479. Your Honor, the state has made offer for a plea and a PTI. I am discussing that with him. If we can get a continuance, I'll make sure he understands the dynamics of that. So
Okay,
if I
and
can get-
I wrote it down as a possible PTI, so that's
Yes, sir,
fine.
but it's a plea and a PTI, Your Honor, so if I can just get a continuance, we'll get it in early to get it taken care of.
All right. February 24th will be your next pretrial. Let's see if we can get it resolved.
Yes,
If
sir.
you want to get it in before that, I mean, it's a very new case, right? It's just from a couple of months ago, so I'm not too concerned about the time, but if you
Yes,
want to
sir.
come in early, you can certainly set it on another docket.
Yes, sir, and I'll wait for them to transport Mr. Hart. Thank
All
you.
right, thank you, Mr. Dudley. Just give me a wave or something, or Deputy Williams will tell me when that happens. Mr. Gilbert.
Your Honor, Michael Gilbert on behalf of River Harper, who
River Harper. You have her?
should be up in a moment.
All right, go ahead, Mr. Gilbert.
Morning, Your Honor. We're here on a change of plea for Ms. River Harper. in 24 CF 1743, 23 CF 1883, 23 CF 2225, 23 CF 2601, 24 MM 3019, 24 MM 3205, and 24 CT 461. Those last three cases are in county court, and Judge Ward has deferred to this court to roll it into a global.
Is that accurate, Ms. Turner?
Typical. Yes, sir, I don't doubt the truth of that, Judge.
Okay.
The terms of the agreement are for 24 CF 1743, count 1 is dismissed with a plea to count 2 and other charges listed below. She will serve 30 to 24 months DOC, credit for all time served, and statutory costs.
What's happening with the misdemeanor, the MM cases?
So those, the first is, the first two are time served. Count 2 is dismissed, and the final one also time served. They're all
Okay, I just want to make sure there's not going to be any probation or anything like that.
Okay, so the terms of the plea are in 24 months DOC, credit for all time served. In 23 CF 1883, defendant admits violation of probation, 24 months DOC, conterminous with 24 CF 1743, credit for all time served. Revoke and terminate also, and VOP violation fee. 23 CF 2225, defendant admits VOP, 24 months DOC, concurrent, conterminous with 24 CF 1883, credit for all time served. 2601, defendant admits the violation, 24 months DOC, concurrent, conterminous with 24 CF 1883, credit for all time served. And then in the 24 MM 3019, time served, 24 MM 3205, time served, and in 24 CT 461, count 1, time served, count 2 is dismissed. Approach.
I'm just going to need a moment more with the score sheet. I think I can get this.
Is it going to be a guideline sentence?
No, sir, this is downward departure based on the legitimate uncoerced plea.
All right, Ms. Harper, can you raise your right hand to be sworn? Right hand, please. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. You've heard everything that's been announced by your attorney. Did you understand all that?
Yes, sir.
All right, did you go over this plea and sentencing agreement with your attorney, Mr. Gilbert?
Yes, sir.
Okay. All right, so basically what you're pleading to is the new charges of attempt to introduce contraband into a detention facility, which is a third-degree felony, as well as possession of a controlled substance, third-degree felony. Then you have the 3 violations of probation in 23 CF 1883, 23 CF 2225, and 23 CF 2601. Then you've got the misdemeanor charges as well. You're familiar with all those?
Yes, sir.
Okay. And this is what you want to do today?
Yes, sir.
All right. Are you currently under the influence of any alcohol, drugs, controlled substances, or prescription medicines that could affect your ability to make this decision today? Do you have any prior mental health issues or concerns that could affect your ability to make this decision today? Do you need any more time to speak with Mr. Gilbert about your case? Has he answered all of your questions? Is there anything that you've asked him to do that he's failed to do for you at this point?
Yes, sir.
Okay. Are you satisfied with his advice and representation?
Yes, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea? All right. And has anyone promised you anything in return for your plea? Do you understand by entering a plea there won't be a trial of any kind on the new cases, and there won't be an evidentiary hearing for your violations of probation? All right. And you understand that you're giving up all of your rights as far as trials and evidentiary hearings, confronting witnesses against you, testing the state's evidence. You understand all that?
Yes, sir.
All right. And you read all that in the plea agreement?
Yes, sir.
And how old are you and how far have you gone in school, Ms. Harper?
I'm 21 and I got my GED.
Okay. Anything in here that you didn't understand?
Hi, this is Alex Barthay from the UPS store in Crestview, Florida. We also have Eglin Air Force Base and Fort Walton Beach. So if you're seeing me, it must mean it's Old St. Nick is right around the corner, and we want to help you to be able to get your packages to your loved ones. So for the UPS store, UPS has deadlines starting on the 20th of this month of December. So if you're trying to get something to a loved one within the continental United States, the December 20th date should
Thank you. Just for the record, I was incorrect when I stated it was a downward departure. This is not a downward departure, but it does not change the terms of the agreement in any way.
All right, so Ms. Harper, as far as the new charges, which is the contraband charge, the possession of controlled substance, 2 petty thefts, driving license suspended, and the failure to appear, what is your plea? Guilty, not guilty, or no contest?
Contest.
Okay, and as far as the violations of probation, are you admitting that you violated your probation in the ways they've alleged, or are you denying that?
Yes, I violated it.
Okay, you're admitting that. Okay. I'm going to accept your no contest plea on the new charges. I'm going to accept your admission to your violations of probation pursuant to the sentencing agreement in 24 CF 1743. So count 1 is the contraband charge is being completely dismissed?
Yes, sir.
Okay. On count 2, it'll be 24 months in Department of Corrections, credit for all time served. 23 CF 1883 is the violation of probation. 24 months DOC concurrent and coterminous with 24 CF 1743, credit for all time served. VOP violation fee, which is 100. Okay. 23 CF 2225, accepted admission of violation of probation, 24 months DOC concurrent and coterminous with the other 2 cases I've already stated. Revoke and term that probation, credit for all time served. 23 CF 2601, accept the violation of probation admission, 24 months DOC concurrent and coterminous with the 3 cases I've previously mentioned, credit for all time served. As far as the MM cases, 24 MM 3019 is a time served adjudication on all counts. I didn't say that already. 24 MM 3205 time served. 24 CT count 1 is time served. Count 2, which is the failure to appear, is dismissed. Do you have a total court cost you can give me on that, or I'll just order all legally mandated court costs, and that amount will be. What are you asking for that, since she's going to DOC?
Well, she may be able to pay it. Can't say she's not.
Or do you want me to send it to a judgment?
We can
We can send it to a judgment.
All right. Cost will be to a judgment. All right. Ms. Harper, you've got to be fingerprinted. You have 30 days to appeal the judgment and sentence.
Your Honor, I have one last thing related to this case. It's a motion for partial remission of bail, of bond forfeiture. It's from another attorney. He sent me a motion. I guess he's coordinated with state, who says they have no objection. I just offered to the
Let me see what it is.
The bondsman wants his money back. Doesn't want to take it away.
Yeah, it is.
Get all that shit.
Good one. I'm looking at a very similar, if not identical, order was signed by Judge Gunterick on November 14th. So I'm not sure we'll need it. It looks like it's already been done. Obviously, if I turn out to be wrong on that, go ahead and give my office a call, and we'll take a look at it.
Wasn't. That's all I have, Your Honor.
All right, thank you. Thank you, Ms. Harper.
Thank you.
They've left.
They left, okay.
I'm assuming they figured it out at this point. I was going to, and then they left pretty quickly. All right. All right, Mr. Powell?
Dan Powell on behalf of Devin Jones, Your Honors, case number 2024 CF 2271. We thought we'd be able to resolve it. We resolved part of the case, but we're going to need to pass it to the 24th, hopefully to resolve the other part.
Okay. Ms. Turner?
No objection.
All right, we had it as a possible plea, but it's only a few months old. I'm not concerned about that, Mr. Powell, so I'll put you on February 24th.
Yes, sir.
We'll
The
see
first
where-
time
Is
up.
your client here?
We have a waiver on file.
Okay. All right, February 24th. Make sure you're all back on that day.
Yes, sir, Your Honor. We should have it resolved by then. It's just,
That was Devin Jones, correct? Okay. All right, thank you, Mr. Powell.
thank you, sir.
All right, Ms. Gooden? I'm trying to track on who came in when, but,
Good morning, Your Honor. Cheryl Gooden for Wesley Bertrand. He's approaching the lectern.
all right, 23 CF 2071. What are we doing today, Ms. Gooden?
Your Honor, I have discussed with my client, we put it on for today because we originally thought we were going to be able to enter a plea. However, that's not possible due to the circumstances. We're ready for trial. We would ask for jury selection Monday, the 20th.
I don't remember this one being set for trial.
No, sir, I did not believe that it was set with subpoenas. If there's not going to be an agreement, we can set it next cycle.
I didn't have it listed as a trial, Ms. Gooden. I mean,
I asked for the continuance because I didn't want to ambush Ms. Turner because she wasn't here and I wasn't able to get a hold of her over the holidays.
okay.
And you set it for today.
Well, I set it for today because in October, y'all said it would be resolved on December 30th. So,
And we anticipated, but because of the situation with the being on community control, he lives in Louisiana, he can't do community control, he'd have to move back to Florida.
okay.
Trial next cycle is fine.
All right. I didn't have it listed as one, not that we couldn't make room for it, but if they did
And
put out
that-
subpoenas for it, then, but it absolutely will be a resolved next cycle.
Right, one way or another.
All right. February 24th for Mr. Bertrand. We'll see you back on that day, sir, and then we'll set the case for trial for March.
And there's a waiver on file, so he doesn't need to be here for the
You wouldn't need to be
pretrial.
here for the pretrial, but he'll need to be here for the docket day.
Yes, Your Honor. And that date is, Madam Clerk? 3/3.
And then trial weeks would be March 10th and 17th.
Thank you, Your Honor. That's all I have.
I think I've got Mr. Nopes. Were you next?
Judge, I have Robert Anderson. Judge, the state and I communicated yesterday afternoon, and she emailed me a score sheet. I've covered that score sheet with Mr. Anderson, and he's still questioning a few charges that he says he doesn't remember ever having those charges.
Okay.
I would ask, could we put it on for Thursday, and that'll give me time to go meet with her?
Is it a guideline sentence plea offer?
It would be, yes, Your Honor.
Okay, so the numbers are important to make sure we got that number right.
Right, to make sure we're on the right number.
We just see how many we've got Thursday at this point. objection to that, Ms. Leone?
No, Your Honor.
All right,
I
let's
don't.
put it on for Thursday, the 9th at 9 o'clock for another potential plea, but just make
Judge,
sure.
I think it'll be a plea. I guess I've never had one that I've said, well, my client says he didn't have those charges. I mean, I don't know if,
It's always possible.
you know, the reality is it's hard for the private lawyer because it's other counties, and I don't have the login information for these other counties, and so, anyway.
Yeah, I remember those days.
Your Honor, I probably can show him. I know I'm not supposed to give the whole CCIS, but probably I can show the charges that is if you tell me exactly what charge in the score sheet is contesting, I can show you the records that I have for that particular charge.
That works. Maybe tomorrow, can I come by?
That's, yes, that would be fine.
That works.
All right. All right,
See you on
come back on the 9th at 9 o'clock.
Okay.
All right, thank you, guys.
Thank you, Mr. Anderson.
Judge, I then have Andrew Barnhill. He's present.
It's not a defense lawyer thing. Because I have it. Yeah, the NCIC you can't show him, and that's because of the user.
Judge, we've attempted to do the depositions in both of these case numbers and the victims. One victim was served and did not show up. The other case, I'm not certain if we served her or not, but she has contacted our office. This is the 23 CF 1308, saying that she wanted to drop charges. We told her she needed to talk to the state attorney's office. And I know it's been the holidays, so I'm not certain where they're at on these cases.
Your Honor, I haven't been able to contact the victim yet.
Okay, so that's the 1308 case. And what did you say about the newer one?
The 24 case, the victim in that case was served, and he did not show for depositions.
No, it wouldn't be. Okay, yeah, it was.
Mr. Nobs, are you talking about the dealing in stolen property case? Well, that's because I think he was incarcerated. He has pending felony charges.
Oh, I didn't realize that.
Yes, that's the reason, I guess. He was arrested, and I think right now he may still be in jail.
Maybe let's just continue it then, and I believe the state if they think he was incarcerated at the time of the deposition.
All right, so you want to put them both in February?
Yeah, I believe so, Judge.
Okay. All right, as far as the 23 case, I'm not inclined to let that one go on another cycle. I mean, it's from June of 23. I understand that y'all are trying to get things done, and sometimes over the holidays they can't be done, but Ms. Leone, if you can get a chance to talk to the alleged victim and get this case resolved one way or the other, so it'll be February 24th
Yes,
on
sir.
each
Will
case.
do.
Yep. So both of them's going February 24th?
Yes, sir.
Okay. Judge, the next case I have is Michelle Kemp. Judge, my office did not contact her and tell her to be here today. I was really, the whole purpose was is the state and I had depositions and then holidays, and then Justine and I hadn't talked. So we had discussed possible resolutions. So if you want to put it on for January 6th or January 9th as well, maybe we can bring it in.
All right. Any issues with that, Ms. Turner?
No objection, Judge.
Okay. I had it as a possible plea, so we'll keep it on for the 9th.
Judge, the next case I have is Stefan Kessler, Kessler, 24 CF 2493, and I just need to get the state's offer. And we might be able to get it resolved if we could put it on for the 9th as well. Once I get the offer, I'll go talk with him.
I believe our office is anticipating a transfer of one of his DUIs into this division. So the offer would be in anticipation of that happening. And that would be an adjudication, 60 days jail, 3 years probation, $1,000 fine, 515 court costs, 50 hours community service, 6 months driver's license suspension, multi-offender DUI school, victim impact panel, 30-day impound, and 1-year ignition interlock.
Judge, I don't believe that we're going to be able to accept that. So I will need to take the deposition on the DUI case.
So there's this DUI case, and there's a misdemeanor DUI
There's a misdemeanor DUI case also.
All right, what are you asking for then, Mr. Nopes?
I'm sorry?
What are you asking for then?
Continued 224.
Any objections to that?
No, Judge.
I just took a quick look. It's kind of hard to tell really which one's which, because there's a CT number that says it's been transferred, but there's also the MM case from 2024. I just want to make sure y'all take a look at. I think we've got another case on the docket today where it seems like there might be a situation of someone being charged in both places at the same time.
Is the state suggesting they're going to transfer the current CT case up here?
My understanding was I was going to, I believe, did I direct file on this count, the existing count in this case?
I've got the information and is driving unsuspended, resisting, and DUI second.
And that's not a direct
And
file?
it says count 3 is a transfer from 24 CT 2565, which has now been closed.
Okay. I believe that's still, so then it sounds like we've filed on the DUI that originated, one of the DUIs that originated in county court, which was what I anticipated.
That's already been done.
Apparently, as long as county courts followed up, you said it was a closed case.
Well,
You
the
should
CT
still
case
have-
number is closed, but there's still a 24MM 2315, which is listed as DUI, refusal, and resisting without.
And my understanding was that there would still remain in misdemeanor court a DUI that was not being transferred.
As long as y'all got the case numbers figured out, that's why I looked at it. It looks a little confusing based on the way it's popping up right now, but just take a look at that and see what y'all want to do with it.
So it was transferred successfully, so that would be the state's offer.
Yeah, the 24 CT did get transferred.
Okay. But again, there's a 24MM that's still listed in a DUI. I just don't want to be a situation where we're trying to figure out if you pled one place versus another. 'Cause I think we've got that issue coming up later this morning with somebody else on a different type of charge, but I want to make sure that we're looking at it.
No, the state's understanding is there's two distinct facts and circumstances supporting two distinct DUIs. If we're mistaken, please, Mr. Nopes, please let me know.
All right, February 24th.
Yes, sir. Judge, I then have J.C. Rockcroft. Judge, is it possible if we just pass him this morning for a little bit?
I'll not talk on Monday?
Well, I got an offer, and he and I talked, yes.
Okay.
Yeah, he come off the talk, but after we sat there and discussed everything, I've got to make a counter offer.
So we'll just pass Mr. Rycroft and call him back up later this morning.
Sit out there and wait on me, okay? Judge William Talbot, I showed that we continued that, but then it ended up on the docket this morning. Got more involved before.
All right. So is this the case where you withdrew your motion to withdraw?
Yes, sir.
Okay, that's where my notes were a little bit suspect. All right, so what are we trying to get done with Mr. Talbot? You said you thought you
There
continued
was a
it.
49-page report. I do have that. I need to go to the jail and give him his copy, but I need to probably set a couple of depositions as a result thereof.
These are really old cases.
I know.
It's my case.
Got a 2020 case here from November of 2020, so it's over 4 years old at this point.
I think the 2020 case is a violation of probation.
Your Honor, may I speak, if you don't mind?
If you'd like to, but obviously make sure you talk to your lawyer if you have any questions before
Sir,
you do that.
The VOP, I'm not trying to fight my VOP. I am honest, I was guilty of that.
Okay, well,
My VOP, like the other charges, they got put on me after I was already violated on my probation. I FTA'd on my court date to come to my VOP hearing. All right, and these charges got through on me in the process of that. So that is a whole totally different case, Your Honor.
I understand, but this is also a violation, this is also the new case. When I say new, the newer case is from September of 22, so we're over 2 years on that one. Does the docket normally say, does it say VOP on docket day? That's what I'm missing, so the docket looks a little bit different today than it did last week as far as what's a VOP and what's not, so I didn't realize the 2020 case was the VOP. But again, even then, the 2022 case is over 2 years old. I'd like to get these things resolved, so, you know.
Because we didn't realize there was another more in-depth report until December 13th, I think.
That's the date I had that y'all had some depositions. All right. Was there an issue about transcripts for those two I have in my notes?
Judge, I've got an order, I believe, that allows us to have them transcribed, and we've sent that, but we don't have the transcripts yet.
Okay. I just want to make sure if there's anything else you need from me so we can get these things moving. I'm not inclined to continue this another time, Mr. Nopes. I'm trying not to give everyone a hard time the first cycle through, but cases that are more than 2 years old without special circumstances need to be resolved.
Yes, sir.
All right, February 24th. That'll be last continuance on this case.
Yes, sir.
Now, obviously, if something crazy happens, witness availabilities and things like that, I'll certainly consider it, but I'm not going to do it just because we're waiting around for things to happen.
Yes, sir.
All right. Thank you, Mr. Talbot. We'll see you back February 24th.
Judge, I then have Ralph Thompson, which I believe he refused.
It is a possible plea. What was the plan?
Judge, I was hoping that the state would give me a global plea offer on all these cases. I've recently been appointed.
It's all petty thefts. There's one stolen property case.
Well, there's a grand theft, larceny, petty theft.
Oh, it's $750 or more.
So these are three of them are November arrest, or I guess arrest.
At this point, he's choosing to stay in jail and not come or potentially resolve these. Is there a plea offer that's been extended?
I'm accessing it, Your Honor. 1 second. His computer is slow. It scores a total of 40.88 months, and that would be the offer guidelines.
Without telling me what he thought about it, have you had a chance to convey that offer, Mr. Nopes?
Judge, I have not.
Okay. All right, so what do you want to do with it today?
224.
All right.
They're not too old, Your Honor, those
Yeah,
cases.
they're not terribly old, but I want to make sure that we're getting somewhere with them. February 24th. What else do you have, Mr. Nopes?
I'm sorry?
What else do you have?
Aaron Zimmerman. Judge, if we leave it set for Thursday, the state and I were discussing that, and then with the holidays, we never got back to each other. I just put it on for Thursday.
All right, January 9th at 9 o'clock.
At 1?
9.
Okay.
Unless you want to sit through arraignments.
Thank you.
Okay. Anything else, Mr. Nopes?
Ask Mr. Rycroft one more.
Call it and just give me an idea on when you're ready. Ms. Dudley, come on up.
Your Honor, this is Colby Hart in 24 CF 1881 and 24 CF 1972. I would ask for a continuance to the next cycle. I was just retained, I think, Friday.
Okay, that's why it's not popping up under your names.
Yes, sir.
Just a sec. Mr. Williams, okay. And this is both cases, Ms. Dudley?
Yes, Your Honor.
All right, 24 CF 1881 and 1972 be continued to February 24th. We'll see you back on that day.
Yes, sir.
All right,
Your Honor, that's all I have.
thank you. All right. Ms. Merrifield, do you have something? Thank you.
My apologies, I was in the south end.
And
My
back
case
up
is-
here already?
Yeah.
That's pretty good.
My cases should be under Flaherty. Brandy Merrifield on behalf of Chase De Roberto. It's 23 CF 2496 and 2489. We had set this case for plea or continued today. We are really close to an agreement. We've got one final thing we need to work out. So ASA Barrickman and I have discussed this and believe that a continuance would be in our best interest, and we should be able to resolve it at the next pretrial. And as the court may recall, this was one that had quite a few witnesses, and there were some that we had some significant difficulty getting a hold of. There is still one witness that would be critical that we have not been able to locate or depose, but we are trying to resolve the case notwithstanding.
All right, I had his plea continuance. I understand that it is getting a little bit older, but if we can resolve it the next time, I'd be happy with that, one way or the other.
Yes, sir.
February 24th for Mr. De Roberto. Is he here today?
There's a waiver on file for Mr. De Roberto.
All right, thank you.
And then the next one I have is Timothy Roberson in 24 CF 2001. There's also a waiver on file. We believed that we had reached an agreement this morning. However, the no contact provision versus no violent contact, we are still working out the details. There is an attached injunction that should be resolved tomorrow. So we're asking to put this on the 9th, anticipating that we can resolve it on that day.
Okay.
Yes, Your Honor.
All right, January 9th
That'd be 9 a.m. for a plea,
at
Judge.
9 a.m.
Wonderful.
So the injunction case is set for tomorrow?
It is, Judge. We
Is that
just
a-
need to
Is that a new case?
figure out the contact issue.
Is that a new injunction case, or has it just been passed previously?
It was previously passed, Judge.
I don't remember which one that was, but.
Yes, sir.
All right, we'll see you back on Thursday.
Thank you, Judge. I believe that's all I have.
All right, thank you. Have a good day. All right, Ms. Flowers, are you ready with yours? Okay. All right. Ms. Rivers, Mr. Russell.
Judge, I have one out of custody, Nicholas Atkins. Mr. Atkins is on page 18, number 44 in my docket. Case number for the record is 24 CF 1457. In this case, Judge, Mr. Atkins was found incompetent to proceed and placed on conditional release back on November 6th. He was already on conditional release on 2 older cases, for the record, 23 CF 373 and 23 CF 531. The state and I have not gotten a report from conditional release, so we don't know what's going on. So what I propose to do is put Mr. Atkins, preferably all 3 cases, on for January 30th at 9, and then I'll see if I can get a report from conditional release as far as what's going on with him.
I was going to make the same request. I believe the case manager was John Barnes, but he's since retired, so we'd want to sort of update the information on who's actually who's managing Mr. Atkins.
All right, so let's put them all on January 30th. That's going to be 23 CF 373, 23 CF 531, and 24 CF 1457.
Yes, sir.
What time are we set for that day?
We do it 9.
All right, 9 a.m. Make sure you're back on that day.
That's no problem. Thank you, Mr. Judge.
Thank you.
Next one, Judge, is going to be Donnie Beck. He should be in the back. Okay. I can. Not for me. I got a couple more I can deal with until he gets up. Judge, next I'd like to call Ricardo Bryan. He's number 46 on page 19 of your docket. For the record, case number is 18 CF 1425. This was passed for today for me to figure out what's going on in the case. This is back on an appeal from the DCA. They had remanded for resentencing and a new hearing on defendant's pro se motion for new trial. We had withdrawn from his case before. We're going to have to withdraw again. So what I propose to do is set it for the 30th at 9 for a status, to give us time to file the paperwork, get RCC on board so they can figure out what they're going to do. But it should not be on the pretrial conference date because, like I said, it's for resentencing and a hearing on his motion for new trial. And Mr. Bryan, for the record, is in Santa Rosa CI. That's why he's not here today.
January 30th at 9.
And then my next case is going to be Akeem Calloway, which is 47 on the docket. Mr. Calloway's not going to be here either because he's in Gulf CI. He's serving a Walton County sentence. There's some notes in the file that
Give me the name again. I'm sorry, Mr. Russell.
Yes, sir.
The name again.
Calloway, number
Okay.
47, right after Mr. Bryan.
I've got it. Thank you.
Case number is 23 CF 923. There's some notes in the file that the state and Mr. Gibbs had worked out a plea bargain to misdemeanors, but we don't have a signed plea agreement. So what I propose to do on him, we can set it for the 30th if you want to try for that, or you can set it for the February 24th, and I can move it up if I can get a signed plea agreement, but we may be able to do a plea in absentia and take care of his case.
That's correct. I had made an agreement with Mr. Gibbs to dismiss count 1 if he will plead to the remaining counts, which are all misdemeanors, do an adjudication. We had talked about 6 months county jail.
That's what the note showed. Concurrent?
I just didn't know how the court wanted to do that. Yes, we could do.
Okay. If that's the offer, Judge, I just have to get an offer to him, get him to sign it, and then we can do it in absentia.
Even though it's county jail?
I'm sorry?
Even if it's county jail?
It's my understanding that you can do pleas in absentia regardless, but if the court wants, I could do a motion in order to transport. Like I said, he's...
I don't want to bring him here if he doesn't need to be. I just want to make sure that that's a new one for me to have someone plead in absentia to county jail while also in DOC.
How would the court feel about a Zoom appearance if I can arrange that with Gulf CI?
I'm fine with that.
State?
No objection.
I just want to make sure that the jail doesn't have an issue that's going to pop up, and then they're going to say we never had them in our custody, so we're not going to give them credit for any of that. And I see one of your colleagues is nodding along with me. It's not that I don't want to do it. It's just I just want to make sure it works.
Yes, sir. So you want to set it for a status on the 30th?
Put on the 30th and see if we can get it to work
Okay.
well enough.
Do you want a formal motion in order for a Zoom appearance, or do you want me to just check with the CI, the prison, and see if we can do it, or?
If they're willing to do it, again, I'm worried about him not being in the Okaloosa County Jail's custody at any point, and them saying, we never had him, he gets out of his DOC sentence, and he's got a hold from Okaloosa County Jail, or he's sitting there for 30 days before anyone figures it out. That's my biggest concern. It's not the not being here. But if they're willing to do it that way, the problem is he's gonna have to be fingerprinted for the.
Is that something that DOC can do for the, or do you want me to transport him?
Why don't we put it on the 30th and see what's gonna work?
Okay.
I know people don't always like to come back from DOC in order to handle cases, but I also don't want him to end up in all sorts of other issues because of it. So just, let's put it on the 30th, see if you can figure out what's gonna work best for him, Mr. Russell. And then if it needs to come in earlier or later, we'll talk about it at that time.
Thanks, Judge.
All right.
Charles Russell, Public Defender's Office. Judge, this is Donnie Beck. Case number for the record is 24 CF 2373. Mr. Beck wants me to talk to the state, so if we can pass his case for a minute, let me talk to them, and then we can bring him back in a minute.
All right, we'll recall Mr. Beck.
Thank you, Your Honor.
Thank you. We'll see you in a little bit. Mr. Webster?
Good morning, Your Honor.
Morning.
I'm here on behalf of.
Can I have you go to that one? Just because when they start talking, I need to see them on that side. Go ahead.
Stephen Webster here on behalf of Francesco Stevens. This is 22 CF 1981.
Okay, so that's number one on our docket.
The co-defendant is Jonathan Reed Roller, Your Honor, and he's currently set for February 24th, and I would just ask that we be put on that docket to travel together.
Okay. And your name again, sir?
Stephen Webster.
Okay, and you and Mr. Baptiste are
That's my law partner.
Okay,
Yes,
that's what I thought. I just wanted to make sure. I'm trying to put it in a connect.
He just had a baby, Your Honor. And
I
so-
read that in the Zoom motion, but unfortunately, the Zoom motion was sent to the previous judge, and I didn't see it till we got here for the 30th.
He doesn't want to miss a second of that baby's
Yeah,
life
I understand
right
that. All right, Ms. Leone, any issues with putting it with the co-defendant on February 24th?
No, Your Honor, but I would ask that this be the last continuance
are
because
very
it's
old
extremely
cases.
old. Yes.
And I think I probably said that to
The other
everybody
one, yes.
last time, so I'll put it on the 24th, but that's the last time up. All right.
you.
Thank you, Judge.
Thank you, sir.
You have a nice day.
You too. All right, Mr. Nopes?
Judge, back to Mr. Rycroft. Judge, by counteroffer, they said they would consider it. However, I think they've got to contact their victim, so we would like to just put it on for Thursday.
No objection.
January 9th, 9 a.m. We'll see you back on that day, Mr. Rycroft. Make sure you stay in touch with Mr. Nope. Sounds like things are making some progress, but he's probably going to need to talk to you before then.
Very good. Thank you, Judge.
All right, thank you. Is that all you have, Mr. Nopes? All right, thank you. All right. Mr. Scott, are you ready?
I'm ready on some of them, Your Honor.
You seem to be very diligently working on some paperwork. I didn't want to bother you, but if you're ready to call some up, I can take it.
We can get a couple of them knocked out, that would be good, Your Honor.
All right.
Which inmates do you need, sir?
Elton Ford.
I do have others. I'm gonna need Jeffrey Brown. And Thomas McDonald. Yes, I need to write something up on Gamble. Kelvin Ford. Your Honor, this is Kelvin Ford. Chris Scott on behalf of Kelvin Ford, case number 24 CF 765 and CF 766. Your Honor, I was appointed.
Just appointed last week, right?
Yes, sir.
Okay.
So I'm obviously still getting up to speed on that. I would just ask that we set this out for a future pretrial.
Any objections from the state?
No, Your Honor.
All right. February 24th will be your next pretrial date. If you need anything else before then, give us a holler. Is there any other motions?
Yes, sir. Thank you.
All right, thank you, Mr. Ford.
McDonald. Your Honor, Chris Scott on behalf of Thomas McDonald, 24 CF 1992, 24 CF 1961. Your Honor, in this case, we were, I believe, coming here today to get a date certain for trial for Mr. McDonald. I believe the state is objecting to that.
I am, Your Honor.
Okay.
For several reasons. So, first of all, I wasn't aware that there was a competency evaluation that was ordered in the misdemeanor case. When I realized that, I communicated with Mr. Scott to ask if he knew about it, and he thought his client was found competent, but we didn't know the whereabouts of the actual report. We found the report on Friday. That report was never filed with the court. We found it on Friday, this past Friday, and since we filed it. So first of all, in order for a case to go forward, there must be an order entered by the court that declares the defendant competent to proceed. The order, we don't have this order as of yet. Second, when defense counsel indicated to me that he intended...
Well, I mean, you have it now. It's been filed.
Because we filed it, we have it now, but there is no order of the court judging the defendant competent. And there must be a written order of that.
If I may, Your Honor, the proposed order was submitted today.
Yeah, it was submitted today. So at the time that he invoked speedy trial and he set the case for trial, we did not have the order. And I discovered that, again, after the case was set. Second of all, when defense indicated that they wanted to invoke speedy trial, I was under the impression that it was actually sort of filing a notice of expiration of speedy trial, because that right is not automatic per the case law that I provided yesterday to the court and to defense counsel. Not only this, when a defendant seeks a continuance in the case, that continuance act has a waiver of the speedy trial. Yes, Your Honor.
I understand, but when was the continuance requested?
The first pretrial. The felony case was continued by defense, the first pretrial. So when that happens, the defense has an obligation to file a demand for speedy trial, and the prosecutor has to be served with that written demand. A written demand for speedy trial was never done, so his request should be stricken. Additionally, there have been some developments in the case. One of the victims is currently being prosecuted, and I haven't had the chance to coordinate with defense counsel to go speak with that victim. That same victim has provided different statements, and it's the state's belief that it's because this defendant and that victim were located at the same jail. So the other victim, the sister of the victim in the case that was actually set for trial, we haven't been able to locate her yet. Second, this happened probably last week. The victim in the case that is set for trial is currently incarcerated in the Santa Rosa jail. And I have been communicating with his public defender to try to go to Santa Rosa and go talk to him prior to the potential trial. I think, Your Honor, that again, there is no demand for speedy trial. The defendant waived the speedy trial. There is no order of competency entered, so the case has to be continued. And I would ask that, again, the continuance be charged on the defendant.
All right. Mr. Scott. Any
Your Honor,
response?
we're a signature away from having the proposed, or having the order on competency. All of this that we discussed, it was last week.
I'm not wrapped around the axle regarding whether or not the competency order's been signed yet.
Yes, sir.
My concern more is, was there at least an implicit waiver of speedy trial based on the continuance back on October 28th?
Your Honor, we haven't requested any continuance that would extend that next court date beyond speedy trial. I don't have the exact date, but by my calculations, speedy's going to run in February. We set it for trial in January at the last hearing. I did not file the demand, but we had it set for trial within speedy. I still have time to file that demand for speedy trial. Your Honor, I don't believe that continuance barred Mr. McDonald from his right to a speedy trial, because that continuance was not set out beyond beyond the speedy trial date. And Your Honor, as far as an expiration of speedy trial being filed, speedy hasn't expired yet, so I have not filed that, but I can file a demand for speedy trial. But what we would ask the court to find is that we are still within the period where Mr. McDonald can be provided that right to a speedy trial, and ask the court to find that that right has not been waived.
Anything else, Ms. Leone?
Well, first of all, Your Honor, that's not the law. The fact that he seeks a continuance and then he does so within the expiration of the speedy trial time, that's not the law. The law, and I have case, this is State of Florida versus Arthur Wright, 389 Southern 2nd 289. That case stands for the proposition that when a defendant seeks a continuance, the continuance acts as a waiver of speedy trial, and therefore he would have to file for a demand in writing, demand for speedy trial.
This is kind of where I'm at with it, and I know, Ms. Leone, you sent an email yesterday to my office, and I'm assuming, Mr. Scott, I
Yes,
saw
sir.
your name was on there, that you received that as well, with quite a bit of case law regarding this particular issue. The problem I have is I wasn't there in October, and I don't really have any notes as to what was actually said in October. So what I'd prefer to do is, if you want to put it on maybe Thursday or Friday, I can go back and review what happened, see if I feel that there was a waiver that was done, who asked for the continuance. All I know is it was continued. I don't have a whole lot of information as to what actually happened that day. And then I can review the case law that was provided by the state. Obviously, Mr. Scott, if you want to provide me with anything, I'll read it before the next date that we have and see if there's any particular issues. But when we were here last Monday, the 30th, I thought we were setting one of the cases for trial. It didn't seem to be an issue at the time, but now the state has potential witness issues. So we may have to address those in more depth as to whether or not that would comply with the 3191 exceptions, if I can grant a continuance even over speedy trial request. I just don't know yet because we haven't gone through all that, and frankly, I'd rather not do it on docket day unless we wait till later and we can take a look at it.
Well, Your Honor, if I may, the issue of the competency was, I think I discovered it after the case was set. And again, I thought that he had never sought a continuance before, so it was within the original speedy trial time. Then later I realized that that was not the case. There was no order of competency. And then also in the last week, the issue with the victim, that he just got arrested and now he's in Santa Rosa. So yes, we can come back on Thursday, Your Honor.
Any issue Thursday or Friday, Mr. Scott?
What time would that be on Thursday, Your Honor?
Did we set anything after arraignment already on Thursday? Just in case that helps.
I'm available in the afternoon. If it's in the morning, I can make arrangements to be here.
That's a VOP evidentiary. Want to put it at 2:30 on Thursday? I think we've got a VOP evidentiary, but that's the only thing after our arraignment docket at 1:30.
That'd be fine.
Works for me, Your Honor.
All right, I want to make it as easy as possible for everyone to be there on relative short notice. Again, I've already received some case law that she sent over to both of us, Mr. Scott, so if you have anything, send it to me and Ms. Leone as well, and I'll certainly read it before that date. Again, I just want to make sure I'm seeing everything since I wasn't here at that court date where the alleged continuance happened, or as to who asked for it or not, so I want to make sure that I'm seeing all the actual facts and not just what we think it might be. Okay. All right, January 9th at 2:30 for purposes of the speedy trial issue. Obviously, be prepared to argue any part of that. As far as the competency issue, was there a waiver? Is there a ability to continue the case because of their witness issues? I'd like to resolve all that in one day if I could. All right.
Thank you, Judge.
All right, thank you. We'll see you back then, Mr. McDonald. Thank you.
Your Honor, if I may also, for the record, I need to serve on Mr. McDonald the notice of intent to seek habitual felony offender sentencing. That can be served. And that's in both cases.
Hey, Steve, have you been able to confirm that or? Represents Mason.
I do, Judge.
Okay.
This is the lady I advised the court back on the 30th that she was ill, but we didn't have time to do a waiver or anything of that nature. I got in touch with her, told her to be here today, and the court had passed it until today with instructions that she needed to be here.
Okay. And
So
she's
she's in
here,
the-
but I understand there's another issue.
She's in the lobby. She is masked. She provided that last bit of detail when I went out 5 minutes ago, so I just.
All right, so what are you asking for on that?
I'm going to be moving to continue it, Judge.
Just for the state, this is Holly Mason, 24 CF 2413. She wasn't here last week. I told her to be here this week, or else it would be a potential capias. Sounds like we need to let her go on her way today.
No
We'll
objection.
just bring her back February 24th.
Thank you, Judge.
All right.
Yes, Judge.
All right, thank you, Mr. Williams. Sorry to interrupt you, Mr. Scott. I just wanted to get that resolved.
Your Honor, Chris Scott here on behalf of Jeffrey Brown, case number 24 CF 1605, 23 CF 2193, 22 CF 1911. And Your Honor, today we have a executed plea form that Mr. Brown would like the court to consider. Judge, since I don't think I've entered a plea in front of you, would you like for me to go through all the terms?
I have to say them all anyway, so I typically, if it's the state's agreement, and I'll read them all out, and then if someone tells me there's an issue, then otherwise you're reading it, and then I'm reading it. It just seems to be a little duplicative.
One second. May I approach, Your Honor?
Yes, sir. Thank you. All right, so is this a guideline sentence?
It is, Your Honor.
Ms. Turner?
Your Honor, I'm getting the score sheet because what I had was incorrect.
Does that change the number that's going to be on here?
Yes. No, Judge. No. I thought you meant on the score sheet. No.
I just want to make sure he's
Yeah,
pleading
yeah.
to the number that's on here for all counts.
Yes, Your Honor.
Okay. All right, Mr. Brown, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your name and how old you are?
Mark Brown Jr.,
All right.
27.
All right, Mr. Brown, you're here, I've been given a plea and sentencing recommendation for 24 CF 1605, which is sale, manufacture, deliver a controlled substance with intent, 15 years DOC maximum, that's a second-degree felony. Corruption by threat against a public servant, which is a third-degree felony, punishable up to 5 years in state prison. Resisting without violence, false name to a law enforcement officer, and possession of drug paraphernalia are all first-degree misdemeanors. Then also there's 24 CF 2193, possession of a controlled substance, third-degree felony, and sale, manufacture, deliver, or possession of a controlled substance with intent, which was cannabis. That's also a third-degree felony. And then in 22 CF 1911, there's a violation of probation. Underlying was a third-degree felony as well. Is this the plea that you wanted to enter today? Okay. And it's my understanding that it's going to be 33.7 months Department of Corrections. Is that what you believe the number to be? All right, Ms. Leone, is that the number you believe?
Yes, Your Honor, it is. And I have the score sheet.
Okay. And does it have 33.75 on it? Yes. Okay. All right, Mr. Brown. Yes. Are you under the influence of any alcohol, drugs, controlled substances, or prescription medications that could affect your ability to enter this plea today? Do you have any mental health issues or concerns that could affect your ability to enter this plea today? Have you had enough time to speak with your attorney, Mr. Scott?
Yes, sir.
Has he answered all of your questions? Are you satisfied with his advice and representation at this time? Has anyone forced, pressure, or threatened you in any way to enter this plea? Has anyone promised you anything in return for your plea? You understand by entering a plea in the two new cases, you're giving up your right to a trial where the state would have to prove beyond all reasonable doubt each of these charges.
Yes, sir.
Okay, and in the VOP, you understand that you're giving up your right to an evidentiary hearing where the state would have to prove by a preponderance of the evidence that you violated your probation in the ways they've alleged. Do you understand you're giving up the right to trial and hearing? And do you understand you won't get a chance further to challenge the state's evidence, and you're waiving any potential defenses that you may have? All right, did you read the plea and sentencing agreement?
Yes, sir.
Do you have any questions about it? Do you understand the rights that you're giving up? All right, how far have you gone in school, Mr. Brown? Like 10th or 11th grade, but you were able to read it and understand it? All right. And what is your plea? Guilty, not guilty, or no contest? All right. All right, the court's going to accept your no contest plea in 24 CF 1605 and 24 CF 2193 as far as the violation of probation, and 22 CF 1911. Do you admit that you violated your probation or deny that you violated your probation? You're admitting that. Okay, I'll accept your admission as to that as well. I'm going to adjudicate you on all counts. It's going to be 33.75 months in Department of Corrections as to each of the felony charges. As far as the misdemeanors, we just want to call that 1129 or time served. Did y'all want to address that? Obviously, I can't give him 33 months for a misdemeanor.
Been in since July? Yeah. 1129.
Okay. All right, so as to the misdemeanor counts, which are going to be counts 3, 4, and 5 in 24 CF 1605, it's 11 months, 29 days in county jail. All of these are run concurrently, correct? Okay. I've got total costs and fines of, let's see, court costs $615 times 2. That's for the 224 cases. And then, well, I'm not sure, there's an 11, what looks like 1140 under that. I'm not sure what that is. So all mandatory court costs, and again, $615 for each of the new cases, $100 VOP fee. Were you appointed, Mr. Scott, or no?
I was appointed, Your Honor.
Okay, so $100 PD fee as well as $50 application fee. All right, again, it will be adjudicated for each count. Anything that I've missed? Was this a state's agreement?
It is the state's agreement.
Okay, and as we've talked about, it is a guideline sentence as well.
Yes.
costs will go to collections. All right, anything else for Mr. Brown?
Not from the defense.
Revoking the old probation?
Yes. Revoke old deal probation. All right. Step over and be fingerprinted, Mr. Brown. You have 30 days to appeal the judgment and sentence of the court.
And Your Honor, I'll step down. I have one more that I need to get written up.
Okay, thank you, Mr. Scott. All right. Is anybody else ready? Ms. Rivers or Ms. Flowers? Okay. Morning.
I can address however you'd like me to go. I have an out-of-custody client that I'm going to be asking to continue. Mr. Cody Lavin,
Okay.
24 CF 2011, Jennifer Flowers on his behalf with RCC. We had originally set for this date in hopes of getting an offer from the state that would resolve, but I've spoken to co-counsel on the case, and they're doing depositions, so we're requesting to continue to be a part of those depositions.
Said co-counsel.
Oh, co-defendant's counsel.
Okay, that's what I thought you meant. I just wanted to make sure I heard you right.
Yes, Judge.
All right. This is plea or continuance, so 2/24 at 9 o'clock. Make sure you're back on that date, Mr. Lavin, and stay in touch with your lawyer. Thank you.
Ms. Lori Brown? Your Honor, Ms. Lori Brown was not here, and Your Honor allowed her to be set for this date. She is here now. She is on a PTI recall. We are asking, she is now aware of the terms and everything that she has to get done. It is my understanding she hasn't I don't know if there was just confusion, but we're requesting to put it on the pretrial for February 24th for her to complete, if the state is willing to give her another chance to complete the terms of her.
The terms included an anti-theft course, $515 in court costs, $9.60 in restitution, and no trespass at Little Caesars. So if she can do those things, you know, relatively quickly, then the state would have no objection to that.
I told her to make sure to pay the restitution, and would the state be willing to, if she entered into a payment plan with the clerk for the court costs, or does she need to get that completely paid?
If that's something the clerk will do, the state has no problem with that.
All right, so let's put it on February 24th. Ms. Brown, make sure you stay in touch with your lawyer. Come back on that February 24th date. Sounds like they're willing to work with you still as long as you get things done in a timely fashion, but obviously no promises made from them until you actually get it done. All right, thank you, Ms. Brown. We'll see you back.
So are you trying to pay the restitution?
Yes.
Can we put on the record that it's to Little Caesars, $9.60 restitution? Just Little Caesars? Pizza. I don't know their corporate name.
Oh, yeah, I thought it was Sefco. Little Caesars
I
inside
have
of
it as
Sefco.
Sefco.
Yeah.
Okay, then it would be my mistake. I thought it was Little Caesars. Yeah.
Pay that restitution.
Thank
to the
you.
clerk's office. Okay, just tell them your case number and they'll have it in there. Okay. Thank you, Madam Clerk, for that clarification. I think that's my only out of custody if we want to start.
I put her on the 24th of February.
This is Justin Cox and 24 CF 1502, 24 CF 2563. Your Honor, I put on today's date, but realized there's also a VOP that I didn't see, so we do not have a resolution today, so we're requesting to continue for either a VOP hearing or.
VOP not on this date, is that right?
I believe it's currently set for January 30th, Judge. That's 23 CF 1502.
Where would you like to put this court,
Could we put this case on January 30th as well with the VOP? Or-
Is it already set at 9? All right, January 30th at 9 o'clock to run with the violation of probation.
Thank you.
David Creech.
All right, Your Honor, we have here, sorry about that, this is David Creech in 24 CF 1442. We had previously set this for trial, but it looks like we have been able to reach a resolution with the state. But I would ask to pass him briefly so I can write up the specific terms.
Okay. All right, Mr. Creech, she's going to write up the terms and have you look it over. We'll call you back up later today. All right, thank you, Mr. Creech.
Thank you. Okay. So Mr. Green, Gerald Green's not here? Okay. Can we set him for, I know he has a 90-day offer that he was wanting to accept. So
Do it
could-
Thursday?
Yes.
All
That'd
right,
be great.
January, for Gerald Green, 24 CF 2150, we'll set him for the 9th at 9 o'clock for purposes of his plea.
Thank you.
I'll just take some away again.
And Your Honor, I believe Mr. Parker was put on today's docket to address what his Nelson hearing.
Sure. All right, Mr. Parker, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir.
All right. Can you give me your name and your age, please?
Terrence Parker, 33.
Okay, and how far have you gone in school, Mr. Parker?
I have a high school diploma.
Okay. We were here about a week ago, I believe it was, and you had some concerns about going forward with your current counsel. Is that correct? Do you still have those concerns?
Yes, sir.
Okay. All right. Are you trying to represent yourself, or are you asking the court to appoint a different lawyer to you? Say again.
Asking the court.
To
for-
appoint a new lawyer?
Yes, sir.
Okay. Do you have any kind of prior experience in legal matters or representing yourself? Okay. And how long have you been in custody, Mr. Parker?
Going on 4 months.
4 months. Okay, I'm showing an arrest date in October, is that right? Okay. All right, well, tell me why you think I should discharge Ms. Flowers and appoint you a new lawyer? Just want to remind, you need to show me that there's a reasonable cause as to why.
I know no knowledge of even my first case alone. Have not even discussed it with her at all. I just keep getting promises that she's gonna come see me, don't come see me. My wife has been trying to contact her office. Her assistant, Amy, keeps telling her that when Amy was answering the phone, was saying that that Ms. Flowers is gonna come see me. Never happens. Ms. Flowers doesn't answer the phone. She blocked my wife's phone number. So it's just like, and then like when
How many times have you seen her in the jail in the 4 months or so that you've been there?
I haven't.
Well, and you're saying 4 months, but it's really not even 3, right? I'm not saying that changes things. I just want to make sure I want to understand the time frame.
Yeah, I've been in since October, the beginning of October.
I've got October 21st, so it's been about 2.5 months, right? All right. And are you saying you haven't seen her in the jail?
Haven't. I was in court back in October I was right here at this podium. She whispered, "I'll be to see you this week," and that didn't happen. And then, like, when my wife calls, the only thing, like, the one time she did talk to my wife, she was like, "Well, I don't know. He's just gonna go to prison." Just like you ain't trying to help me.
Okay. You understand that lawyers aren't really obligated to talk to family members, right?
At least I
just want to make sure you understand that.
Yeah, I mean, I get it.
Okay.
But I mean, if you ain't gonna come to the jail and come talk to me, at least relay a message to my wife so she can tell me, so I know what's going on. I got 3
Have you been
cases
told
right
about
now.
a plea offer in your case?
No, sir.
Is there a plea offer in the case?
Not yet, Your Honor. He just got arrested for a brand-new case, 24 CF 2902. So I know it's going to be a DOC offer. I just don't know how long yet because I have to work out the score sheet with the new case.
And Your Honor, if I may.
Go ahead, Miss.
Okay, Your Honor, I was appointed to his new law violation. He also has 2 pending violations of probation. I met with him, talked to him on the phone several times, coordinated, had a bond hearing, got him out on bond on his VOPs. Even with a pending new law, the state argued a felony offender of special concern. We still got him out because that was a juvenile case. He then got another charge, a misdemeanor, that was going to violate his VOP and leave him without bond. I coordinated with the sheriff's office and him via my cell phone for him to turn himself in and have a bond signed by Judge Ward that Mr. Mall stipulated to make sure that he didn't violate and not have a bond on that case. Then he gets another violation, a technical violation of probation. Then he is, let's see, at this point, he's got 1, 2, 3, 4, 5 open felony cases. One is as recent as the 23rd of December. When you talk about his wife, I talked to his wife several times. I told her to stop. I was kind enough to share with her my cell phone number so that I could coordinate his issues, going above and beyond. And then she proceeds to give my number to at least, I've had to block at least 5 numbers. They're calling me at all hours of the night, 3 a.m., calling me, yelling at me. And yes, I've had to block 5 numbers. And honestly, and I haven't gone to see him at the jail since then because I know, I can't even get up to speed on these cases. He scores out to prison on his violations of probation alone. And I worked his cases to begin with. I will continue to work them diligently. But if he just keeps getting new arrests, like he's got to give me some time. And also have his family members stop calling me from a million different numbers. Like I'm having to change my phone number possibly because of Mr. Parker.
Go ahead, Mr.
There's only one number that's calling her. One. It was only one to begin with, and that was my phone that my old lady has right now. Was my phone. She blocked the number. Clearly, she has not spoken with her since I've been in jail, besides the first time when I first came to jail.
All right, and what about what Ms. Flowers said about setting up your bonds and getting you out?
No, they didn't hit me with the habitual violent offender until I was already incarcerated when I had a bond hearing. And that was in October when the state screamed.
But I did set a bond hearing for you and you got out on bond.
I didn't get out. I've been in jail since October. I did not get out. You said you was coming to talk to me. You have not still yet to come talk to me.
Has a bond.
I don't have a bond. I'm held without bond.
Well, on the VOPs, you don't have a bond, right?
I don't have a bond because the state screamed habitual violent offender because of a burglary charge. I never got out. I've been in jail since October.
Okay, but having the violation of Mr. Parker, the last 3 sentences I've tried to speak to you, you've interrupted. And I'm not trying to be difficult with you, but you've got to have a give and take here. And if you don't want the information I'm trying to give, or at least listen to the questions that I may have for you, this is not really going to go anywhere. So I'd appreciate if you could just wait your turn. I've given you more than ample chance to talk about what you have, and once I say anything, you're going to have a chance to respond. So you're not going to get kind of railroaded out of here. You're going to have plenty of time to tell me. But you've got 2 violations of probation for which you're not entitled to a bond. You understand that, right?
Yes, sir.
Okay, but you have a bond on all of your new cases. Is that right?
Correct.
Okay, but even if you bonded out on those, you can't get out because you've got the violations of probation pending, right? Okay, so, and you also picked up a new charge less than 2 weeks ago, or approximately 2 weeks ago? Is that right? Okay, so things have changed numerous times throughout your case based on new charges, is that right?
I don't know what's changed.
Well,
honestly. I got cases that I know nothing about. Like, literally, the charges that were put on me, I know nothing about anyway.
Which ones are you specifically talking about?
This last case that I was just booked with and the case before that.
Okay, so you were just arrested 2 weeks ago on that?
Yeah, that I know nothing about, like, literally.
All right, and you appointed to that one already?
Not yet, but I was,
I see
Wait, I
that
was
she's not even on that case yet. Ms. Rivers, you're still listed as the lawyer on that one, and it's not even set for plea day until January 30th.
And Your Honor, we got the case last week, and we will be filing a motion for conflict due to representation of another person that's involved in the case.
Again, and I'm not trying to pull you into it other than just explain to Mr. Parker that Ms. Flowers hasn't even received that case yet, and there's nothing for her to go over with you because she doesn't even have discovery yet. She hasn't been assigned the case yet. So, she can't really do things before she's given what she needs. In fact, she's not even on that case yet. So, what I'm inclined to do is to keep her on your case. She seems to be working for you, but you have to understand the timeframes that we're dealing with here is they haven't even filed on that case yet, the best I can see. So she can't even legally ask for discovery yet until there's an information filed.
And I wasn't saying, like, I don't know anything from her about that case. I'm saying, period, in general.
Well, I understand, but what we're here for is to whether or not she has been representing you properly. And your chief complaint, other than not talking as frequently as you'd like, is that she hasn't told you about a case that she's not assigned to and is only 2 weeks old.
I wasn't referring to that case. I mean, I know nothing about my first case that even violated my probation.
And which case is that?
I don't know by the numbers, but the Grand Theft Auto, not Grand Theft Auto, fleeing in a loon, driving while license suspended, and I think it was resisting arrest. That's what originally violated my probation.
that is a flat-out lie. We've discussed the facts of that case multiple times. We have a defense
Do you know what
strategy
case number
we
that would
developed
be, Ms.
together.
Flowers? I'm trying to keep track of all these things because there's so many cases, Mr. Parker.
It would be
I
24
understand.
CF 1816 is the fleeing attempt or attempting to
Okay.
elude, which is the original case that violated his probation. Just to be candid with the court, I probably will be filing a motion to withdraw once it's approved by my supervisor based on the basically harassment that his family has put me through. So to let the court know that that will be coming.
I don't even have the 1816 case on my docket unless it's somewhere else. All right, Mr. Parker, what I'm going to do is I'm going to deny your request on the Nelson hearing. I feel that that Ms. Flowers is doing what she can with what she's been provided to with up to this point. Obviously, Ms. Flowers, if you file a motion, I'll certainly entertain that as well. If ultimately the Regional Office of Conflict Counsel can't assign you new counsel or withdraws, I can potentially appoint someone, but I'm not going to do it based on the Nelson request.
Last thing, she said she went over the case with me. When did she go over it with me? She hasn't seen me.
I don't know that. I mean, you're talking about the 1816 case?
When did she go over it? She
Are you
just stated
talking
that
about the 1816 case?
The first case, yes, sir. The one that violated my probation originally.
And that case goes back to July. She hasn't come to see you since July?
Not seen her. I talked to her one time about getting a bond on a misdemeanor charge
That is
when
not
I was out
true.
on bond. So she got me a bond here. I'm a bond on it. So I turned myself in and got back out. Okay, my ankle monitor went dead is how I ended up back in jail because my ankle monitor went dead. So pretrial filed a warrant on me. That's how I ended up back in jail, was because of my ankle monitor.
So you did talk to her?
That was when I was out.
In this
I have
courthouse.
not talked to her about that case at all. We have not discussed that case. We have not went over that case. I don't even know if it's a discovery to that case. I have not talked to her at all about my cases. Not one, not about nothing. The only thing I have talked to her about literally was getting that bond when I was on the street. So she told me to turn myself in and I would get back out. That was it.
And you got back out?
Yes, sir. But as far as
Did you
discussing
make
the
any
case,
appointments with her after that?
I was in jail.
I thought you just said you got back out.
I got back out, but I had a court date.
Then you got arrested again.
I had a court date 2 weeks after, but pretrial already had put in because of my ankle monitor. So I ended up in jail because of my ankle monitor. I have not discussed nothing with her, no case, no nothing. So she's sitting here literally telling a lie, saying that she discussed
But
the
when
case
you
with
were
me.
out of jail, did you make any appointments to go see her?
How could I? I had a court date. She told me to make sure I was in court, so I made sure I was in court.
Well, you've got her phone number. We've established that.
She does not answer the phone.
And her office doesn't to set
No,
appointments?
they does not. Her assistant, Amy, does not do nothing. Don't answer the phone, nothing.
Again, I'm denying your Nelson request. Ms. Flowers, if you have a motion to file, I'll consider it. But, sir, I mean, you've got at least 1, 2, 3, 4, 5, 6, 7 open cases.
I understand, and that's why I need somebody that's going to communicate with me. This ain't my first rodeo. I did 11 and a half years in prison. Just being honest, Your Honor.
Well, I understand that, but at the same time, you're in jail, you're out of jail, she's communicated with you. Can I finish, Mr. Parker?
Sir.
It's gotten beyond frustrating at this point that you don't want to listen because you're too busy waiting to say something next.
I'm listening.
You've been in and out of jail several times during this case. You didn't make any appointments when you were out of jail. I'm not saying that 2.5 months isn't, there should be at least a jail visit in that time, but there's also perpetually new information in your cases because there's new cases every couple of weeks, couple of months, right? And your chief complaint, other than her not seeing you, was a case that she's not even assigned. So I'm not denying your Nelson request. What would y'all like to do with your case today?
I mean, what else can I do?
All right, February 24th, Ms. Flowers, if you're going to file a motion, please do it quickly, and I'll
do it today.
readdress it at that time.
Thank you. Your Honor, this is Christina Russell, 24 CF 1569. She got put on today's docket. We're not prepared for trial in this case. This case,
I had it as plea or continue.
okay. I have a bond motion that's supposed to be being filed this morning, so that's what we need to hear is a bond hearing, but I don't think that's, there's an
It's
issue.
been filed. I don't think I can address it yet.
Yeah, it should be filed today. The issue on the case was, it's a burglary charge, but then there was a failure to appear that caused her to not have have her bond revoked. And we just haven't been able to address the bond issue. I haven't been able to get her on a miscellaneous docket. I was out of town and then out of town again. I basically have been out of town for the last 2 miscellaneous dockets, and that is my bad, but they were
How quickly
pre-travel
can we get it
plans.
set? Is there a bond motion filed? You said it's going to be filed today?
Yes, it was written this morning and emailed to my assistant, so it should be filed before the end of the day.
How quickly do you think you could get it heard?
If the state would allow us to do it on Thursday, that's a miscellaneous date, right?
It is. There are victims involved. I need to have time to communicate with them and seek their intent to whether come to court and participate or not.
January 9th at 9 o'clock. But let's make sure that motion's filed today.
Yes, I will.
All right, this is 24 CF 561.
All right, Your Honor, this case was previously, 24 CF 561, this previously was set for plea or trial, but we have reached a resolution with the state. There was a final matter that I just communicated to Mr. Sparrow, but we have gone over this plea agreement prior to right now. He just needs to sign off on the final copy that reflects the most recent agreement. And this will be a plea down from an attempted homicide to an aggravated battery. And I believe it's still a downward departure. This square sheet's attached, if I may have.
All right, is this the state's agreement?
It is, Your Honor.
Okay, so in 24 CF 561, it's a plea and sentencing agreement. Count 1 would be reduced from attempted homicide to aggravated battery, and count 2, which is the aggravated assault deadly weapon, would be dismissed. Is that right?
That's correct, Your Honor.
All right, and it calls for community control followed by probation. And the guidelines still show a 48.9-month lowest permissible prison sentence. This is a downward departure.
It is, Your Honor.
State's agreeing to that as well.
It is. Yes, the state agrees.
Okay. All right, Mr. Spar, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Okay, can you state your full name and date of birth, please?
James Franklin Sparrow, 7166.
Okay, Mr. Spera, in 24 CF 561, you're currently charged with attempted homicide, count 1, which is a first-degree felony punished by up to 30 years in state prison, an aggravated assault with a deadly weapon, third-degree felony punished by up to 5 years in state prison, but you've worked out the sentencing agreement. Have you gone over it with your lawyer?
Yes.
All right. Are you currently under the influence of any alcohol, drugs, controlled substances, or prescription medications that could impair your ability to make this decision today? Any mental health concerns or issues in the past? All right. Did you have a chance to read through all of this? Did you understand it? Do you have any questions about it now? Did you have enough time to speak with Ms. Flowers, your attorney, about this agreement? All right. And did she answer all of your questions? Is there anything you asked her to do that she's failed to do on your behalf? Are you satisfied with her representation?
Yes.
Okay. Anyone force, pressure, or threaten you in any way to enter this plea? Anyone promise you anything in return for this plea? All right. Do you understand that by entering a plea, you're giving up your right to a trial where the state would have to prove these charges beyond all reasonable doubt? And do you understand that you'd be giving up your right to confront and cross-examine witnesses against you, call witnesses on your own behalf, testify on your own behalf, or remain silent, which is your right? You understand you're waiving any potential defenses that you may have? All right. And what is your plea? Guilty, not guilty, or no contest?
No contest.
All right. I'm going to accept your no contest plea as freely, voluntarily, and knowingly given. Count 1 is to a lesser included of aggravated battery, which is a second-degree felony, correct? Punished by up to 15 years in state prison. Do you understand that if you were to violate your probation, you could get that sentence? Okay. Sentence will be adjudication of guilt, 1 year community control, followed by 3 years of standard probation. You're complete an anger management class, ECLC, or similar drug treatment or counseling. Do you understand what that program is? Have you talked to anyone about that program?
I know what to do with that.
Okay, I just want to make sure if you had any questions about it, you could address them now. No contact with the victim in the case unless the victim requests that contact in writing. Court costs, and an aggravated battery. Okay, so 615 plus 151 and 101? 201. $150 cost of defense, no restitutions being ordered at this time, waive cost of supervision. And does the state have an announcement in count 2?
The state dismisses count 2.
Okay, so that's 615, 151, 201. All right, anything else from Mr. Sparrow? All right, step over, be fingerprinted. You also have 30 days to appeal the judgment and sentence. You're going to talk to probation at some point as well this morning. Anything else that the state wants to put on the record as to the plea?
No, Your Honor, that's all.
Your Honor, this is Christopher Stearns. We're here today in 24 CF 1853 and 24 CF 2625. She wouldn't agree. Okay. And Your Honor, we have reached an agreement with the state. We have previously gone over this agreement, but we're waiting on one thing, then he is signing off on the final document. May I approach?
Yes. All right, Mr. Stearns, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your name and date of birth, please?
Christopher Stearns, October 14th, 1992.
Okay, and Mr. Stearns, you're here in 24 CF 1853, where you're charged with possession of a controlled substance, the third-degree felony, and 24 CF 2625, where you're charged with tampering with evidence and possession of a controlled substance. Again, both also third-degree felonies. I've been handed this agreement. Is this what you want to do here today?
Yes, sir.
Did you have enough time to go over this with your lawyer?
Yes, sir.
Did you understand everything in this plea agreement, including the rights that you're waiving and the conditions of probation that you would have to complete?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances that could impair your ability to make this decision today?
No, sir.
Any prior mental health issues or concerns? All right. Did you have enough time to speak with your lawyer about this?
Yes, sir.
Did she answer all of your questions?
Yes.
Are you satisfied with her representation in this case? Anyone force, pressure, or threaten you in any way to enter into this plea?
No.
Did anybody promise you anything in return for this plea?
No.
You understand by entering a plea, you're giving up your right to a trial and all the trial rights that are mentioned in the agreement that you signed? All right. And what is your plea?
No contest.
No contest.
All right. How far have you gone to school, Mr. Stearns?
I finished high school.
All right. I'm going to accept your no contest plea as freely, voluntarily, knowingly given. In each count, it's going to be adjudication, 3 years probation, concurrent. In the 24-1853, it's going to be substance abuse evaluation, recommended treatment, $615 court costs, $150 costs of prosecution, waive costs of supervision. In the 26-25 case, another $615 in court costs, $150 cost of prosecution. Also waive costs of supervision for each of those. Substance abuse evaluation and recommended treatment will be for both cases. The way I said it sounded like it was only for one, but it's for both, correct? All right, and then you were appointed, Ms. Flower, so $150 cost of defense. I think I was saying cost of prosecution. That should have been cost of defense, $100 cost of prosecution. The $150 is cost of defense. All right, anything else for Mr. Stearns? All right, that was adjudication of guilt on each case as well. You're going to talk to probation today. I'm going to need your fingerprints as well, and you have 30 days to appeal the judgment and sentence of the court. This is a guideline sentence, correct?
No, sir, this is, he only scores 26.3 points.
Yes.
Maybe I misheard you, Judge.
It is a guideline sentence, correct, is what I said. So it is. I read it. I just want to make sure I say it out loud in case someone thinks I got it wrong or something. Yeah, he didn't score.
Your Honor, this is Joshua Summers. I'm going to ask that we pass him just briefly. We had discussed something, and there's one little detail that I need to discuss with him before he enters his plea. So if we could pass him, it's just going to be.
Okay.
I'll bring you back out.
Mr. Summers, we'll call you back up when you're ready.
Your Honor, this is Calvin Tipton. We, again, have attempted to reach a middle ground, and the defense would be ready for trial.
All right, who's on Tipton?
Yes, sir. This would have to be on trial next time. Will be some outstanding motions, a child hearsay and a Williams rule.
Okay. In which case are we talking about the trial?
Your Honor, one of them's a VOP, so.
16 is a VOP?
Yes, sir. So it would be 2280, or 894.
Can I give you the score sheet when they call the case?
And I have discussed that issue with Mr. Tipton, and we have no objection to
So trial, but we're going to put it off to the next cycle.
Yes, please. And I will have those motions filed and the motion hearing set prior to that, of course.
Please, I'd rather hear those well in advance of trial so we know what we're dealing with. You said it's child hearsay and what else?
And a Williams rule, Your
Williams
Honor.
rule, okay.
And Your Honor, on the child hearsay, is it the court's preference that I go ahead and provide the copy of the disc with the motion?
Any objection to me referring to that or reviewing that
objection.
ahead of? Okay. I'd rather review it when you all don't have to watch me watch it. So once that's filed, send a copy over to my office.
I will do that, Your Honor, and I will notify Ms. Flowers so that she's also aware of that.
All right. So otherwise, we'll put it on for February 24th. So we can set it for that date and then set a trial from that date and get those motion hearings. Does that understand, Mr. Tipton?
Yes, sir.
Okay.
Thank you, Mr. Myers.
Thank you.
Your Honor, this is Taquan Watson and 24 CF 1838. The defense is ready for trial.
Who has Watson for the state?
It's mine, Your Honor.
Ready for trial?
There's been an amended offer. Let me discuss this.
Pass it?
Yes.
Okay. All right, Mr.
Yeah.
Watson, she'll come back and talk to you, and then we'll decide if you're going to go forward or not.
Thank you.
Mr. Watson turned 18 yesterday.
Um,
It was one of my juvenile cases.
Is that all my inmates, I believe? Christopher Willis? Again, if we could ask him for me to, I'll just talk to him. I didn't get to meet with him. Is there anyone else that I'm missing?
Thank you.
Taylor? Was that, oh, okay. Oh, yeah, Miss Megan Taylor is present and approaching. We, when we exchanged contact, we haven't been able to properly go over the discovery in her case. I thought we might get it resolved today, but it is brand new. So we're asking to continue it to the 24th for me to just be able to go through the full discovery exhibit with her.
No objection.
Your continuance, it's a relatively new case. February 24th, stay in touch with your lawyer, Ms. Taylor, so y'all have a chance to talk about the discovery, and we'll see what you want to do next time around.
Thank you, Judge. All right, Your Honor, thank you. I will go and talk to these people and be back. Thank you.
All right, Mr. Scott.
Can I get Bravin Gamble, please? Your Honor, this is Bravin Gamble. Case number 23 CF 1540, 13 CF 641. And Your Honor, we have an executed plea to present to the court
Okay.
for consideration.
Thank you, sir. I've seen much worse. Don't worry about that. All right, Mr. Gamble, can you raise your right hand to be sworn? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir.
Can you state your full name and date of birth, please?
September 1st, 1996.
Your full name?
Raymond Elias Gamble.
Okay, Mr. Gamble, you're here. I have a plea and sentencing agreement in 23 CF 1540. Count one, aggravated battery on a law enforcement officer, second-degree felony, resisting with violence, third-degree felony, depriving officer of a means of protection, third-degree felony, grand theft over 750, third-degree felony, and then count 5 is crossed off. Is that being dismissed?
The amended information did not include count 5.
Okay. So there is no count 5. Then also you have 13.
Well, it should be added to the plea because, I mean, I'm not dismissing it.
Let's see.
She ain't dismissing. We can set up for pre-trial.
I mean, I'm still agreeing to the 24 months. It's just that it needs to be addressed.
You filed an amended after this?
Yes, sir, I did.
I'm showing the amended information was filed on June 26th.
You said the amended, Your Honor?
Yes. Possession of a firearm or ammunition by a convicted felon.
Yes.
We would like to resolve that count as well.
Okay, can you just fix that on your form so it's your handwriting again and not mine?
Yes, sir.
You already wrote it, but then it got crossed off, so I want to make sure it's there. Mr. Gamble, do you understand there was another charge of possession of a weapon or firearm by a
No, sir,
convicted
I was not aware of that. This is my first time ever seeing that charge. I've been here 18 months, never seen that charge.
Okay. Well, do you want some more time to speak with your lawyer about that?
Sir.
Okay.
We would ask for the next pretrial, Your Honor.
Well, then, Your Honor, if I may, I would like to set this for a VOP evidentiary. I'm not keeping this open for another 3 months. I was just offering the 24 months to close it on time.
Can we possibly bring it back Thursday?
It works for me.
You're going to be here in the afternoon,
Yes,
right,
sir.
Mr. Scott?
2:30.
All right, so we'll do Thursday, the 9th at 2:30. He'll talk to you about it and see if you want to accept the offer as is. Otherwise, the state's intent, as they've just announced, is to go forward with your violation of probation evidentiary hearing first.
Sir.
Okay, we'll see you back on Thursday.
Let's see if I can talk to you here at the courthouse. Thank you, Judge. That concludes. Okay, that concludes my business, Your Honor.
All right, thank you, Mr. Scott.
Your Honor, number 56 on the docket, Jason Walterman, 24 CF 1518. Walterman is present and approaching. And Your Honor, this matter is set for trial. It's my understanding in speaking with the state, they filed a motion to continue. Defense has previously requested motions to continue.
Any objection to the
No, Your Honor.
current motion to continue?
No, Your Honor.
We would actually have to move orally to move to continue. I thought it was filed Thursday. It wasn't, so that was my intention, Judge.
What's the reason for the continuance?
The-
I know you weren't here on Monday when we announced that.
The long day. We need the time to expedite the FDLE report, Judge.
This is only from July, so February 24th. Put that on for a pretrial date and see if we can get things done by then.
And the time, Your Honor, is it 1:30?
1:30, since he's not in custody.
1:30. on the
That way you don't have to sit here all Monday morning again like you did last week.
2/24. Your Honor, the next one I have was one you just appointed me to in court. That's Mr. Peacock, Justin Peacock, 23 CF 2819. And Your Honor, I have spoken with him briefly. We don't have any discovery or anything yet in this case because it is so new.
New to you.
I'm sorry?
New to you, right?
New, yes, Your Honor, new to me. Your Honor, he did provide me with the name of a witness. I did physically hand that over to the state attorney. And in speaking with Mr. Peacock, he does wish a trial.
We'll put it on the pretrial next time and see if y'all can get some sort of discovery moving. I think I just appointed them to your case, Mr. Peacock, last week, right? All right, February 24th, that'll be at 1:30.
And if you can bring your Thank you. Or by phone, something.
Okay.
And those, I believe, are my out of custody. Your Honor, this is Tyler O'Quain before the court on 22 CF 523 and 21 CF 1972. We were previously before the court for sentencing. He had entered a plea, but sentencing had been set off due to him completing the ECLC program. Then when the court was going over the plea agreement, there was some questions, and Your Honor gave him time to meet with me again to decide whether he wanted to withdraw his plea or go forward.
And the issue was, I think, like an early term or something like
Correct,
that?
15 years and early term at 10 years. And Your Honor, also too, I do have a printout from an email from Tucker Cantler from the Okaloosa County Jail, which indicates that Mr. O'Quain is out on bond on 21 CF 1972. So he has not been getting any credit for the time he's been in. And it shows also in the email that he has been in jail since February 23rd, 22 on his other case. So it should have been on this case as well. So we're asking for credit from February 23rd, 2022 until today on 21 CF 1972, as well as the 4 days credit from before on 21 CF 1972.
What was the resolution as far as it's going to
You
be the
have any
15
other?
years probation but may early term at 10?
There's also DOC time associated with that.
Oh, yeah, I've got that part. Yeah. I'm just trying to focus on the one issue that was an issue last week.
I resolved it with my people, Your Honor.
Okay. I just wanted to make sure that
Yes, sir.
you understood, because I think last week when we were here, it was a little confusing.
I just needed to talk to him. I talked to him, and we're okay.
Since I didn't take the plea, I wanted to make sure that you were familiar with all the terms, but let me get you to go ahead and raise your right hand and be sworn. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor, I do.
Okay. And can you state your name and date of birth, please?
Tyler O'Quinn, 05/19/1996.
Did the state have any concerns with the credit for time served issue as far as him being out on bond even though he's been in jail the whole time?
Your Honor, we are aware that he has been in jail during that time, so we have no objection to all the credit that he's legally entitled to. So there's
Okay.
no objection to
I
that.
just want to make sure that there's no
That was
concern.
one of my big concerns too, and she handled that with me.
And I'm more than willing, Your Honor, to submit this from the jail.
Well, I can see that's the date he's been in jail since. I just, just unfortunately, when you get picked up on something else, unless you turn yourself in basically on the bond, even though you're in jail, you're not getting credit. I've dealt with that situation numerous times when I was a practitioner as well, so I know how it works. The other thing I wanted to ask you, Mr. O'Quain, since I didn't take your plea, do you have any objection to me entering the sentence that you agreed upon already?
No, Your Honor, I do not.
Okay, and just for the record, I've reviewed the file. I've become acquainted with the facts of the case. I understand what the plea offer was and what's been accepted. I just wanted to make sure if you had any concerns with me handling it from this point on, you make those known now.
No, I do not, Your Honor.
Okay, thank you, Mr. O'Quain. All right, so in 21 CF 1972, you entered pleas to make sure I'm getting this right because put X's next to, I think, some of the counts, and I can't tell if those are the ones that you meant to, that's what you pled to, or that's what was coming off.
I'm not sure who put the X's there, Your Honor.
Sorry, Your Honor, could you repeat that?
I'm just trying to make sure I get the right counts.
Your Honor, we had a plea to 1, 3, and 5.
Okay.
No pros on 2 and 4 on that particular case, 1970.
Okay,
Correct.
and then on 523, it's both counts?
Your Honor, that was, we're pleading to, or he pled to count 1 and count 2. The unlawful use of the two-way device was no pros based on double jeopardy.
Okay, and that's what it seems to indicate. It's just sometimes when someone puts an X there, it means that's the one we're taking away. Sometimes it seems to be the one that's what they're pleading to. I just wanted to make sure it was clear. So, Mr. O'Quain, in the 21 CF 1972, you entered a plea to counts 1, 3, and 5, and then in 22 CF 523, you entered a plea to count 1. Agreed upon sentence that you already entered a plea for was 60 months in the Department of Corrections, credit for all time served. I'm going to make sure I spell that out. It's my understanding that you've been in continual custody since February 23rd of 2022 on the 22 CF 523 case. You were technically, quote-unquote, out on bond in the 21 CF 1972 case, but there has been an agreement that you get credit for time served in both cases going back to February 23rd of 2022, plus in the 21 CF 1972, the original 4 days that you had served before you were initially released before the new arrest. I'll give you that credit towards the 60 months Department of Corrections as part of your sentence. Also, there's 15 years of sex offender probation. You may potentially early terminate it at the 10-year mark. That doesn't mean it's guaranteed to happen, but as long as everything's done, it can be addressed at that time. GPS monitor at $1 per day. Designation as a sexual offender. You'll have to do sex offender counseling. No internet access. No contact with minors. Sorry. Zoom in a little bit. That may be modified after a risk assessment being done as part of your probation. $867 in court costs, $100 cost of prosecution, $100 PD fee, and $50 application. I think this is the one thing too. It says waive GPS on here. It should be waive cost of supervision, correct, Ms. Rivers?
Correct, Your Honor.
Okay. Anything that I've missed?
No, Your Honor, and we gotta have a recommended structuring of that sentence if the court wishes.
Oh, go ahead.
Your Honor, as some of the counts are only third-degree felonies, and one of them is a second-degree felony, we'd recommend that on.
Which is a second-degree felony?
That's gonna be count 3, Your Honor.
Count 3.
That's the only one that is the second-degree felony. So if the court wishes to go ahead and announce the structuring, or I can make the proposal.
If you want to, I read it as it was on here, but if you want to tell me how you, because you can only get the 5 years total for the third-degree felonies.
And Your Honor, so we're recommending on count 21, 1972, counts 1 and 5, the third-degree felonies, that the court impose the 60 months DOC concurrent with each other.
Okay.
And then count 3 would be the 15 years sex offender probation consecutive to counts 1 and 5. And then 22, 523, count 1 would be 5 years DOC concurrent with counts 1 and 5 of 21, 1972.
Okay. I'll restate that, but Ms. Rivers, any issues with that?
No, Your Honor.
Okay, so on the three cases or counts that were third-degree felonies, that's in 1972, counts 1 and 5, and then the sole count in the other case, it'll be 5 years DOC. And in the second-degree felony charge, count 3 of 1972, it's the 15 years sex offender probation. That can be early term, potentially at 10 years, which is consecutive to the 5 years DOC sentence in the other 3 counts.
That's correct, Your Honor. Thank you.
All right. Any response to that, Ms. Rivers? Anything else you want to say about that?
No, Your Honor.
All right, I think we've got it right then. All right, adjudication of guilt for each count as well. Mr. O'Quain, you're going to have to be fingerprinted, and you have 30 days to appeal the judgment and disposition, or I'm sorry, judgment and sentence of this court. Do we have a score sheet? Was that filed already? I think it was, back on November 4th. It's there. The thing I'm looking at, it was 67.05, so this is a plea bargain departure.
Yes, Your Honor.
Okay. About 7 months. All right. All right, thank you, Mr. O'Quain.
Okay.
Sir, I'm sorry, I didn't hear you.
I said thank you, sir.
Thank you.
Was he re-fingerprinted? Yeah. I guess from the last time.
Agreement in this matter, Mr. Stewart just needs to sign the agreement. So it says 13 months DOC on each count. No bond thing. Yep. CTS, credit for time, sir. Cut it off. So if you would. If you'd sign it right there. 13 months. Last line, Your Honor, I previously typed this out. The last line we've already addressed, so I was just wading through that. Okay. Mm-hmm.
All right, Mr. Stewart, raise your right hand, please. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, you're here on 3 cases, 23 CF 2784, which is fleeing or attempting to elude third-degree felony, 2785, which is flee or elude or attempt to elude at a high speed and drive while license suspended. That's a second-degree felony and second-degree misdemeanor, respectively. And then 2786, flee or attempt to elude third-degree felony, resisting without violence, first-degree misdemeanor, false name to law enforcement, first-degree misdemeanor, and driving while license suspended again, second-degree misdemeanor. I've got a plea agreement that calls for 13 months in the Department of Corrections. Is that what you want to do here today? Okay. Can you state your full name and date of birth?
First name Stewart, 10/10/2002.
All right. And Mr. Stewart, are you under the influence of any drugs, alcohol, controlled substances that could impair your ability to make this decision today? Do you have any mental health issues or concerns previously? Did you have enough time to go over this agreement with your attorney, Ms. Rivers? Did you understand it? Do you understand all the rights that you're giving up by entering this plea? And are you satisfied with the advice of Ms. Rivers? Has anyone forced, pressure, or threatened you in any way to enter this plea? Has anyone promised you anything in return for your plea? Okay. And what is your plea?
It's no contest.
I'm going to accept your no contest plea on all cases, all counts, adjudicate you guilty, all cases, all counts. In 23 CF 2785, it'll be 13 months DOC with credit for any time served. 415 court costs, $100 cost of prosecution, $100 PD fee, $50 application fee. And 23 CF 2786, concurrent 13 months DOC on count 1, concurrent 11 months, 29 days in Okaloosa County Jail on counts 2 and 3. Credit for time served on count 4, which was the driving unsuspended. 415 court costs, $100 cost of prosecution, $100 PD fee. 23 CF 2784 is another concurrent 13 months DOC. 415 court costs, $100 cost of prosecution, $100 PD fee. Did I miss anything?
And Your Honor, you did indicate credit for all time previously, sir?
I did. If I didn't, I'll say it again. Credit for all time served. Guideline was 40.575, so this is an agreed upon downward departure state.
Well,
Yes?
it is, yes.
Okay. All right. Mr. Stewart, need to be fingerprinted. You have 30 days to appeal the judgment and sentence of this court.
Your Honor, this is Tony Tatum before the court on 24 CF 2304, and we are announcing ready for trial.
State?
No, Your Honor, the state is not ready because only recently we discovered that he has also VOP cases that should have been opened. He was never he was served on the VOPs, but the jail never delivered the warrants to Benchmark, and Benchmark never opened it until, I believe, either Friday or this morning. So I haven't had the chance to obviously meet with the victim. I would ask that the case be set 10 days from now, whenever we have the next miscellaneous for a VOP evidentiary hearing. And that would likely resolve also the new law, the outcome of the VOP evidentiary.
Rivers, your response?
Your Honor, he's not waiving his right to a speedy trial. And the alleged victim has already filed a statement with the courts. Or, I'm sorry, filed a statement that we filed in our discovery.
He was served back in October of the VOPs? They're just not assigned a court date?
Benchmark, I mean, the clerk was not even aware that those VOP should have been opened because I understand the logistic is that they receive the warrant from the jail once it's served and then they open a case, reopen the VOP case. So we emailed the jail last week, like I think Friday, to ask why the VOP were not open. We asked the clerk responded, and then we told the jail, and jail said that it was an oversight that they had not delivered the served warrants to Benchmark for opening it.
Right, I'm showing those are now set for January 30th. Are you going to be ready to go forward on that day?
On the VOP, yes, evidentiary, we can set it, Your Honor, with subpoenas, of course.
Ms. Rivers, what do you estimate his speedy trial date is?
I can find out, Your Honor,
Do
the
you have
exact.
that readily available?
No.
1 second. So Speedy expires on 3/25/25, March 25th.
We could still do it the next time around.
Yes, Your Honor, we could, exactly.
All right. I'm going to put it on the February 24th pretrial date, and then January 30th will be the 2 violations of probation evidentiary hearings. Does everyone agree that'll be the actual evidentiary hearing dates?
And what time would that be? Afternoon,
We may need
morning?
it like an hour, I guess.
Morning or afternoon?
I'm just trying to look to see what we've got right now. Do we have anything later? Oof, we do. 2:30.
That'd be fine, Your Honor.
We've got 3 other people that at 2:30, so.
One of my other cases is, yes, Your Honor.
All right. Ms. Rivers, in the Tristan Stewart case, looks like we missed one of the counts. One of the drive on suspended was just going to be, let's see, 60, or just credit for time served.
Yes, Your Honor.
Okay. The drive on license suspended. There was 2 of them. I only gave it to him on 1. He was only on there once. All right, next case.
Yeah, I'm gonna tell them.
Oh, you're gonna tell me?
Yeah, yeah, yeah.
All right.
Your Honor,
Hold on a second.
he's asking to talk some more about it.
So you want to bring it back later today?
Yes, Your Honor, if we could.
I just made an amended offer. That's what it is, Judge.
And if you could say it out loud,
Oh, yeah.
just so I could get the terms
Yes,
correct.
the amended offer, Your Honor, would be to admit to the VOP, plead to attempt on count 1 of the new case, revoke and terminate supervision in the VOP case, and new terms concurrent with the new case. 1 year drug offender probation with curfew 7 to 7, followed by 2 years of probation, complete outstanding requirements, BIP, if not already ordered, no contact with the victim unless she requested in writing to probation.
What about the year of DOC?
I'm sorry? No. No.
It's a year of
Okay, so just,
maybe DOP, drug offender probation.
Oh, DOP, yes.
so the offer. Your Honor, if we could, yeah, if I could meet with them, yeah.
But you want to come back later today?
Yes,
All right,
yes, he
we'll
does.
recall it.
No, you're good. You're good. It's not prison.
Go ahead, sir.
Yes. Hello, Miss Davis.
I've got it, thank you.
Mr. Gibbs ever give you your score sheet? It is. She was not willing to change anything, so I told her we would leave it. Okay, so you want to. Your Honor, I believe we have now reached an agreement in this matter. I'm going to have to draw up a plea agreement. I have it. Actually, I think I already have one typed up. All right, so that makes you a convicted felon, just so you understand that part. It's 30 days, Okaloosa County Jail, court costs. All right, and you've done your 30 days. Okay, so you're going to need to sign it right there.
Yes.
Yep, yeah, you do it,
So we
whatever.
get some of it.
Yep.
Oh,
Oh, you're good. Today's the 6th. And I've already score sheet for her to. Yep, thank you, ma'am.
All right, Ms. Davis, can you raise your right hand to be sworn, please? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
yes.
All right, can you state your name and date of birth, please? State your full name and date of birth, please. Okay, and Ms. Davis, you're here in 24 CF 2357, charged with driving while license revoked, and that's a permanent revocation, I think is what we had talked about last time. All right, there's a plea and sentencing agreement for 30 days county jail, credit for time served, and some costs, is that right?
Yes.
Is that what you want to do to here today?
Yes.
Did you go over the plea form with Ms. Rivers, your attorney?
Yes.
Did you understand it?
Yes.
Did she answer all of your questions?
Yes.
Are you satisfied with her advice and representation?
Yes.
Are you under the influence of anything that could impair your ability to make this decision today?
No.
Drugs, alcohol, prescription meds, anything like that? Okay, well, it's a question I've got to ask of everybody, ma'am.
Okay.
Any mental health issues or concerns that could affect your ability to make this decision?
No.
Anyone force you to do this?
No.
Okay, you gave me a look when I said that. Are you concerned that anyone's forced, pressured, or threatened you in any way to enter this plea?
No.
Anyone promise you anything in return for your plea?
Fish. No.
I'm sorry, ma'am, is
No.
this something that's humorous?
No.
Okay, I'm just trying to ask you questions I have to ask everyone as part of what's called a plea colloquy to make sure you understand what's going on here.
Yes, sir.
All right. And the more that you
I'm
gotta.
a jokester. I'm sorry.
Well, I understand, but the more you do that, the more I'm gonna have to make sure that you understand what you're doing here today.
Yes, sir.
So I appreciate it if you could cut the jokes.
Okay.
Okay. All right, did you read all of the rights that you're giving up by entering this plea?
Yes.
Did you understand those?
Yes.
And what is your plea?
No contest, sir.
All right, Ms. Davis, I'm going to accept your no contest plea, adjudicate you guilty, 30 days county jail, credit for time served, $415 court costs, $100 cost of prosecution, $100 PD fee, $50 application fee. You understand all that? All right, step over, be fingerprinted. You have 30 days to appeal the judgment and sentence of the court. This is a guideline sentence.
Dowell?
Your Honor, this is Cheyenne Dowell before the court on 24 CF 2538. This was a case where Turner was not here today. There was originally a PTI offer, but then Ms. Dowell was taken into custody on an alleged violation of pretrial release. The state that was covering for Ms. Turner was unaware if that offer was still going to be offered, and so you had put it on for today.
Okay.
I've had an opportunity to review I believe it's a misdemeanor, county court case that she was arrested on, but it does involve, the victim in our case was a witness, at least, to the incident there. So I'm going to ask for time to reach out to the victim in this case to see if she has any change pertaining to the offer that was made. So at this point in time, that offer would be revoked, but I'm going to be contacting the victim to see what we can do going forward.
So, Your Honor, could we possibly do it at the next court date, the 9th or 10th?
Okay, hold on just a second.
If you're able to.
Excuse me.
So there was a violation of pretrial release for the new charge, but wasn't there also a no contact order in place?
I do not know.
I believe in this matter, there was no contact with the victim, and when law enforcement investigated, there was a battery count, as well as they learned about she was having contact with the victim, so they charged, in misdemeanor court, I believe they charged 2 counts.
All right, do we want to put it on Thursday?
We could put her on for Thursday, but if I haven't been able to reach the victim, we'll have to just
And
continue.
that's understood.
Thursday, January 9th at 9 o'clock, fingers crossed they can reach out, otherwise we may have to continue at that point.
That's all I have is, yes.
Did you read what the argument was about in the misdemeanor
Oh,
case?
I haven't even seen it.
All right.
I printed out the sheet and I gave.
Your Honor, Chris Scott standing in for Charles Williams.
For Charles Williams, I was like, Mr. Williams is right there.
For Keith Shanklin, 23 CF 2250. And Your Honor, in this case, I believe Mr. Williams and the state are working on a resolution, but have not been able to come to terms on that. I understand there's an offer of about 12 months. And currently, Mr. Shanklin currently has about 10 months in the county jail. Is that accurate?
Yeah, it appears to be accurate as to his time. The early plea offer from October of '23 was 12, a year and a day. I believe to follow the score sheet, it would be about a minimum presumptive sentence of 16.5 months.
So, Your Honor, without a resolution today, I would just ask that it's set for a pretrial, so Mr. Williams can continue working on that.
Any objection to setting it for a new pretrial?
No objection, but state's going to revoke that 12-1 offer that's been outstanding since October of '23.
Your Honor, I would ask that,
I mean, it's been a 12-1 offer for over 12-1. So.
A long time.
that's
Okay.
I have no control over that.
I'm saying that. Wait, so I can go home. I got a sick.
Your Honor, I don't know how much the court has going on that Thursday docket. Would it be
Probably more
possible-
than we can handle, but we'll do it.
If the state would leave this open and allow maybe Mr. Williams an opportunity to speak to his client about this before the offer is revoked? Just as a suggestion.
All right, well, let me just make sure I kind of rephrase. He hasn't been in that entire time.
Okay.
Since October of '23. He got out in December and went back in May. So he doesn't have
Understood.
anywhere near the 12.1 as far as credit. All right. Ms. Turner, do you want to leave it open and come back Thursday or just?
Yes, I can leave it open this cycle.
So when do you want to put it? It's not your case, I know, Mr. Scott, so I don't want to ask you when you want to hear it again.
I mean, we do have Friday. I don't know if the court's, it doesn't matter to me.
Is Mr. Williams going to be here for anything else, do we know?
I'm not sure, but obviously I am.
I know, but it's not your case. So.
Right.
It doesn't matter to me. I'll be here Thursday. So.
I know, I'm just trying not to set something where Mr. Williams is not going to be here.
And I don't have Mr. Williams' calendar. I apologize, Your Honor.
I don't see him listed for either Thursday or Friday.
Give me probation, so I got somebody sit home sick.
All right.
I really need
This is what I'll put it Thursday at 9 o'clock, the 9th. If Mr. Williams can't do that, he can certainly file a motion to continue it or just have, inform us and we'll move the court date. But Mr. Shank, that sounds like they're only willing to keep this offer open until the end of the week or that Thursday when we come back. So you can talk to your actual lawyer, Mr. Williams, about that. Otherwise, if it's not taken, it sounds like they're going to withdraw the offer and then you'd have to renegotiate or plea or trial.
I was going to ask the state if y'all can give me a suspended sentence. I'll take it. If it wasn't for, I have somebody at home really sick and I don't even live here anymore. That's the whole thing. Trying to get to the house so I can take care of it.
I understand. I'll let your attorney negotiate that with them if that's something anyone's willing to do, but I'm not going to engage in a negotiation about it. All right, thank you, Mr. Shanklin. We'll see you in a couple days.
Your Honor, I'm also standing in for Charles Williams on Landon Whittington, who is a juvenile. I believe the court wanted Mr. Whittington to be updated on the progress of his case. From what I understand, he's not here, not transported. Right. So I would imagine the court would still want to give Mr. Whittington an update on his case. Since Mr. Williams is
This
here.
case is a year old now, and I'm not giving you any grief.
Yes, sir.
Obviously, it's not your case, but I think he's very young.
15, I believe.
I don't believe it's quite accurate that we needed to inform Mr. Whittington what's going on. Mr. Williams stated in court that he was going to go see Mr. Whittington to see what kind of information he was able to provide to the state. And I haven't heard from Mr. Williams since last pretrial date, so.
I mean, the issue is I wanted to make sure that they're communicating and
Right.
this case is moving along because Mr. Whittington's obviously very young. He's got quite a few very serious charges. I just want to make sure the case is progressing because it's a year old.
Can we set it perhaps for the 9th and maybe he can reach out to Mr. Williams?
I'm just worried that we don't know if Mr. Williams, just like the last case, we don't know if he's going to be here that day.
Right, so.
Has there been an offer made in the case?
So far, the offer is to plead to the court on the charges that he has.
All right, then I want to have him come in. Let's put him Thursday at 9 o'clock as well. Again, if Mr. Williams can't do that, he can ask for us to change it, but something needs to be addressed on the case one way or the other. These are very old charges. Mr. Whittington was originally in my division before, so I'm familiar with it. I just want to make sure things are progressing due to his age and status.
And Judge, that concludes Mr. Williams' business. I'll see you this afternoon.
All right, thank you, sir. Flowers, did you have something you wanted to recall?
Yes, Mr. Willis is present and approaching in case number 24 CF 2253. We have reached an agreement with the state. This is a plea to a misdemeanor on count 2, so there's no score sheet, if I may approach.
All right, Mr. Willis, can you raise your right hand? Do you swear or affirm that testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes. All right, you're here in 24 CF 2253, currently charged with possession of a controlled substance and possession of drug paraphernalia. I've been handed a plea and sentencing agreement that the state would dismiss count 1 in return for count 2, credit for time served, adjudication, and some costs. Is that what you want to do here today? Yes. Have you gone over this form with your attorney, Ms. Flowers? Has she answered all your questions?
Yes, sir.
You satisfied with her advice and representation?
Yes, sir.
Anyone force you to do this plea? Are you under the influence of anything right now? Anyone promise you anything in return for your plea? You understand there won't be a trial of any kind if you accept this plea? You understand you're giving up all your trial rights that are listed in this report or this agreement? All right. And what is your plea? All right, I'll accept your no contest plea to the possession of drug paraphernalia only. Count 2, adjudicate you guilty, credit for time served, $270 in court costs. You'll pay those within 90 days. All right. No score sheet because it's a misdemeanor. And just to announce for Mr. Russell, Mr. Rivers, Miss Rivers, Mr. Williams, I was trying to go too fast. I'm going to take about a 10-minute recess once Ms. Flowers finishes up. If that helps you do anything, just comfort break for everybody. All right. Go ahead, Ms. Flowers.
Yes, we're recalling Mr. Creech, David Joseph Creech, in 24 CF 1442. We have reached an agreement with the state. If I may approach with the plea.
Yes. All right, Mr. Creech, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your name and date of birth, please?
David Joseph Creech, March 13th, 1981.
Okay, and Mr. Creech, you're here in 24 CF 1442, currently charged with possession of a weapon by a convicted felon, second-degree felony, tampering with evidence, third-degree felony, and possession of drug paraphernalia, first-degree misdemeanor. The plea and sentencing agreement calls for you to basically get the dismissal of count 1 and time served and some costs on the others. Is that what you want to do today?
Yes, sir.
Okay. Have you gone over this form with your attorney?
Yes, sir.
Has Ms. Flowers answered all of your questions? Did you have enough time to do that? Anything in here you didn't understand? You understand you're giving up your rights to a trial if you enter a plea?
Yes, sir.
All right. Are you under the influence of anything at this point? Do you have any mental health issues or concerns that could impair your ability to make this decision?
Sir.
Anyone force you to do this? Anyone promise you anything in return for this? All right. And what is your plea? As to counts 2 and 3?
No contest.
Okay. I'll accept your no contest plea as to 24 CF 1442, counts 2 and 3. That's the tampering and the paraphernalia charges. Adjudicate you guilty, credit for time served, $615 in court costs, $150 cost of defense. There should be a cost of prosecution, right? $100 cost of prosecution.
That's included in the 270, or the.
That's included in the $615, okay. And your money's payable within 90 days. You got that, Mr. Creech?
I do have a score sheet if I may approach.
Okay, please. And this is, so there's still, this is a downward departure.
Yes, Your Honor, it is.
All right, thank you, Mr. Creech. You have 30 days to appeal.
And Your Honor, we're recalling Mr. Joshua Allen Summers in case number 24 CF 1865 and 24 CF 0460. We previously have gone over this plea agreement and the terms therein. Mr. Summers just needs to sign his name.
Yeah.
It's been signed by all the other parties. And I do apologize to the court. This is a little small writing. If there's any questions.
All right. Mr. Summers, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. You're here in 24 CF 1865, which is 2 counts of failure to register, and 24 CF 460, another count of failure to register, all third-degree felonies. Have you gone over this agreement with your lawyer? Okay. Can you pull the microphone over at him a bit, just so I can hear? I know you're nodding and I can read your lips, but the record can't do that, so
Yes, sir. I got you.
It's okay. All right, so is this what you want to do today?
50 months, yes, sir.
50 months to DOC with credit for time served?
Yes,
Okay. All right, did you have enough time to go over this agreement with your lawyer?
Yes, sir, I did.
Did you understand it all?
Yes, sir.
How old are you and how far did you go in school?
I'm 37. I got my GED.
Okay, were you able to read it and understand all the rights that you'd be giving up?
Yes, sir.
Did you have enough time to talk about it with Ms. Flowers?
Yes, sir.
And did she answer all your questions?
Yes, sir.
You satisfied with her advice and representation?
Yes, sir.
Are you under the influence of any drugs, alcohol, or controlled substances?
No, sir.
Do you have any mental health issues or concerns that could affect your ability to make this decision today?
No, sir.
Has anyone forced you to do this?
No, no,
Has
sir.
anyone promised you anything in return for your plea?
No, sir.
You understand that by giving up, by entering a plea, there won't be a trial and you won't have a chance to challenge their evidence, and you're waiving all potential defenses that you may have?
Yes, sir.
Okay. All right, and what is your plea? So it's a plea to count 1 in 24 CF 1865. The other 2 counts will be dismissed. Is
Yes,
that
sir.
right?
Yes, sir.
Is that what you want to do?
Yes, sir.
Okay, and what is your plea to count 1?
Guilty.
No contest.
No contest.
All right, I'm going to accept your no contest plea in 24 CF 1865. That's again count 1, failed to register, state have an announcement, and count 2, and the other case as well.
Your Honor, as to 24, count 2, loss, and then
Okay. So it's just the 1 count. It's going to be adjudication of guilt, 50 months in the Department of Corrections with credit for time served. It says concurrent, but I think it's only 1 count now. So it probably changed as y'all went through this, but just nothing for it to be concurrent with. And then standard court costs, public defender fee. And,
Oh, that's a $150 public defender fee.
okay.
So I can't waive that. Oh, yeah, sorry. I would've-
All right. Anything else from Mr. Summers? All right. And this is a guideline sentence, correct? That's what I have. All right. All right, thank you, Mr. Summers. You have 30 days to appeal the judgment and sentence of the court.
Thank you, Your Honor.
Thank
Y'all
you.
have a good day.
You too.
Lastly, Judge, we're recalling Mr. Tyler Watson in 24 CF 1838. We have reached an agreement with the state wherein some charges are going to be dismissed and he'll be entering a plea to a misdemeanor. So there is no score sheet attached. We have gone over the plea. Mr. Watson just needs to sign. If I may approach.
Mr. Watson, can you raise your right hand to be sworn? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Do you swear? All right, your name and date of birth?
Juan Watson, 010507.
All right, you're here in 24 CF 1838, currently charged with armed burglary of a dwelling, which is a life felony, theft of a firearm, 2 counts. Those are each third-degree felonies. All right. Apparently, the agreement is the state's going to dismiss both the burglary and the count 2 theft of a firearm, and it'd be lesser included misdemeanor petty theft for count 3. Is that right?
That's correct, Your Honor.
Is that what you want to do today, Mr. Watson? Yes, sir. Okay. All right. Did you have a chance to go over this agreement with your attorney?
Yes, sir.
Did you have enough time to do that? Did you understand it all?
Yes, sir.
Did your attorney, Ms. Flowers, answer all of your questions?
Yes, sir.
And are you satisfied with her advice and representation?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances? Okay. Do you have any mental health issues or concerns that you've previously been diagnosed with?
No, sir.
All right. Has anyone forced you to take this plea?
No, sir.
Anyone promise you anything in return for your plea? You understand if you plead, there won't be a trial, and you're giving up all your trial rights that are talked about in this agreement?
Yes, sir.
All right. And what is your plea?
Contest.
And that's the count 3, lesser included of petty theft. Is that right? All right. I'm going to accept your no contest plea as to the lesser included misdemeanor petty theft on count 3. Is counts 1 and 2? State, have an announcement.
The state dismisses count 1 and 2.
All right, adjudicates you guilty on the petty theft misdemeanor, credit for all time served, $270 in court costs, $150 cost of defense. Money is payable within 90 days. And since this is a misdemeanor, we don't need a score sheet. All right. Thank you, Mr. Watson. You need to be fingerprinted. You have 30 days to appeal.
I believe that's all I have.
All right, thank you, Ms. Flower.
Oh, yes.
Wasn't that somebody else's case and now it's yours?
Mr. Weaver, right here. I don't have a case number, and I believe I was just recently appointed, so I would ask just to continue to put it on for trial on the 24th of February.
The offer in the file that I would be honoring today, Ms. Flowers, I know you were just put on, but it would be adjudicate time served and court costs. And this is 24 CF 2056 for the record.
All right. You want a second to talk about that?
Your Honor, I think Mr. Weaver is ready to enter a plea of no contest in exchange for that agreement with the state of credit for time served. Oh, do I need to write it down?
If you could write it up, otherwise I'll just have to go through the really long colloquy, and then we're going to take a break, and I'll call you back up first to get you done with that. All right. Anyone else that we absolutely need to call right now? All right, let's take about a 10-minute recess.
All right. It's just all done, right? I'm good with that.
Okay.
Thank
I just have to write it up for you to sign.
For years, I've proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple: to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those. Hi, I'm attorney Michael Gilbert, and from all of us here at Warrior Law, we wish you and yours a safe and happy holidays.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Hi, this is Alex Barthay from the UPS store in Crestview, Florida. We also have Eglin Air Force Base and Fort Walton Beach. So if you're seeing me, it must mean it's Old St. Nick is right around the corner, and we want to help you to be able to get your packages to your loved ones. So for the UPS store, UPS has deadlines starting on the 20th of this month of December. So if you're trying to get something to a loved one within the continental United States, the December 20th date should start letting you know that we're getting close to having parts of the country each day cut off. So go to ups.com. You could see the calendar on the website. Also, on this ad, you're going to also have the flyer that shows the dates, so you can fine-tune whatever it is that you're trying to ship out to a loved one, what part of the country. If you're sending to deployed men or women, to APOs, FPOs, I would suggest getting in the mail sooner rather than later, because it's going to take during normal times 10 to 12 days. 10 days, 2 weeks is probably a better gauge on shipping. So get those packages going to our deployed men and women around the world so that they can have a happy Christmas as well. In other parts of the U.S., you can also refer to the post office's website for those particular locations. Shipping outside the U.S., give it time.
Take it easy with her, but now it's an ongoing.
We're recalling Mr. Weaver and 24 CF 2056. We have reached an agreement with the state, and it's been signed. Mr. Weaver just needs to sign it. There you go. Actually, let me look.
We had previously asked the court for an order revoking bond. I was going to ask the court to recall that, but because he's in
It was.
All right, so there was an order granting state's motion to revoke bond back on the 30th. All right, so is it Weaver, am I saying that right?
Yes, sir,
Can
you
you
are.
raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
Okay, and can you give me your full name and date of birth, please?
Christian Michael Weaver, January 11th, 1990.
Okay, and Mr. Weaver, you're here in 24 CF 2056, charged with possession of a controlled substance, as well as loitering and prowling. It's a third-degree felony and first-degree misdemeanor, respectively. I've got a plea and sentencing agreement here calling for adjudication of guilt, credit for time served, and some costs on both counts. Is that what you want to do here today?
Yes, sir, it is.
Okay. All right, did you go over this agreement with your attorney, Ms. Flowers?
Yeah.
Okay. I know she was recently appointed, but did you need more time to speak with her about this? All right. Has she answered all of your questions that you've given to her at this point?
Yes, sir, she has.
And are you satisfied with her representation for the short time that it was? Okay. Are you under the influence of any alcohol, drugs, controlled substances? All right. Do you have any mental health issues or concerns? All right. Did anyone force you to do this? Anyone promise you anything in return for your plea?
No, sir.
You understand there won't be a trial of any kind, and you're waiving all your trial rights that are mentioned in this agreement?
Yes, sir.
Okay. Do you understand you're waiving all potential defenses that you may have to these charges?
Yes, sir.
All right. And how far have you gone in school?
10th grade.
10th grade. And you understood everything in the plea agreement? All right.
Sure.
And what is your plea?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudication of guilt on both cases, both counts. Credit for time served, $615 court costs, $150 cost of defense. When you put that little line through the triangle, it just for some reason throws me off. Cost of defense, and so those payments will have to be done within 90 days. You understand that, Mr. Weaver?
Yes, Your Honor.
Otherwise, I just want to make sure I say on the record, will be released as to this case today, despite the order granting the revocation of bond, since the case will be over at this point. I want to make sure that's clear. All right, any other questions, Mr. Weaver?
No, Your Honor.
All right, and this is a guideline sentence, correct?
Yes.
Yes. 90 days to pay. I thought I said that, but maybe I didn't. All right, thank you, Mr. Weaver. You have 30
Thank
days
you,
to
Your Honor.
appeal.
Thank you, Judge.
Thank you.
Your Honor, if I may have no, just a no, it's moment, we went over the terms, but I just want to go over them one more time.
Is this under your name?
Yes,
Okay. Just so I can find it while you're doing that.
it's Robert Curtis Willis, Your Honor. All right. All right, so he's going, no, he's going to have to sentence you, okay? He's going to ask you some questions.
All right, Mr. Willis, can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Okay. Can you state your full name and date of birth, please?
Robert Curtis Willis Jr., 12/27/91.
Okay. And how far have you gone to school, Mr. Willis?
Did
I
you
can't hear
graduate?
you. Oh, yes, sir. I graduated, went to college.
Okay, you went to college. All right. All right, you're here in 21 CF 3281, which is a violation of probation, and 24 CF 2162, which is one count aggravated battery
On a pregnant
on a
person.
pregnant person. Okay. If you say so. That's a second-degree felony. The VOP was an underlined third-degree felony. From my reading of your agreement, did you go over this with Ms. Rivers? Did you understand it? Okay. All right, in 21 CF, it's to revoke and terminate your probation, credit for time served, and some costs. And then in 24 CF 2162, it'd be a plea to a lesser included offense of attempted aggravated battery. Wouldn't that be assault?
No, Your Honor, it would not be.
Okay.
But it would go down, it would go down
It'll be basically
levels, so it'd be a third-degree felony.
Okay, I just want to make sure then. All right, attempted aggravated battery of a pregnant person, and then goes through the probation terms. This is what you want to do here today? Okay. All right. Did you have enough time to go over this with Ms. Rivers? And did you understand everything? Did she answer all your questions? Okay. Are you satisfied with her advice and representation? Are you under the influence of any alcohol, drugs, or prescription medicines? Any mental health issues or concerns for you? Has anyone promised you anything in return for this plea? Has anyone forced, pressured, or threatened you in any way to take this plea? All right, do you understand by entering a plea to the new charge that you'd be giving up your right to a trial, where the state would have to prove that charge beyond all reasonable doubt?
Yes, sir.
All right, and do you understand the VOP? You're giving up your right to a hearing where the state would have to prove that you violated your probation.
Sir.
All right, do you understand you're waiving all of those trial and hearing rights that were talked about in this agreement?
Yes, sir.
And do you understand you're waiving any potential defenses that you may have? Okay. And what is your plea to these two cases?
No contest.
Oh, no contest.
Okay. Is it a withhold or an adjudication?
It would be an adjudication, Your Honor.
Okay. On both?
Yes, Your Honor.
Okay. All right. Mr. Willis, I'm going to accept your no contest plea as freely, voluntarily, knowingly given. Again, in 21 CF 3281, revoke and terminate your probation, credit for time served, $100 cost of prosecution, $100 PD fee, $50 application fee. 24 CF 2162, you entered your plea to a lesser included offense of attempted aggravated battery of a pregnant person, 1 year drug offender probation, followed by 2 years of regular probation, substance abuse evaluation, right?
She gives them the option, Your Honor, substance abuse evaluation, completing recommended counseling, or complete ECLC.
Okay.
Comply with.
Well, my only question while I stumbled is it says SAFE. What's the S stand for?
Follow any,
Okay.
follow the evaluation, follow evaluation.
Okay, substance abuse and follow evaluation, okay. Or ECLC, Batter's Intervention Program, no contact with the victim in the case unless she requests so in writing to probation, waive cost of supervision, $967 in court costs, $100 cost of prosecution, $100 PD fee. Anything that I've missed?
No, Your Honor, not from the state.
Okay, is that for just this particular case? You always want me to say that, Mr.
Oh, no,
Barr.
in this particular, I know Mr. Willis, and me and Mr. Willis went back and forth over the weekend, and
Okay, so who's the person?
I'm getting the name, Your Honor. Oh, maybe.
And while they're doing that,
It's the victim in the new case, the girlfriend, the defendant's
Well-
girlfriend.
what's her name, Rob?
well, I'm going to make sure I look it up and tell it.
Miss Coward, Keondra Coward. Yeah.
All right, so you know we're talking about Miss Coward. Okay. All right, and this, I'm looking at this as a 16.35 month lowest permissible, so it's an agreed upon downward departure?
Yes, Your Honor.
Okay. All right, any questions, Mr. Willis? All right, make sure you do everything that you're supposed to on here, and we hope not to see you back anytime soon.
And Your Honor, the outstanding monies on the VOP or to collections?
Yes, sir. Oh, and Mr. Willis, you have 30 days to appeal.
Charles Russell, Public Defender's Office. Judge, this is Donnie Beck. For the record, case number is 24 CF 2373. On my docket, it's page 19, number 45. The state has, think that they worked out a plea agreement on this case, but they need to run it by the victim. So they're asking, can we set this for the 10th? And between now and then, they'll contact her and find out what she wants to do.
You want the 10th?
Yes, sir, at 9.
All right. Friday, January 10th at 9 o'clock for purposes of a potential plea.
Thank you, Your Honor.
All right, thank you, Mr. Beck. Who do we have
I've
next?
got a few that are out.
Sorry?
Let me go ahead and call them. Sebasterian Fletcher Gillette. Judge, he's approaching. This is one of Mr. Gibbs' cases. I made a counteroffer to the state of 4 years probation. I think we had him here to see if they would accept that.
Well,
It is a downward departure.
I'm not ready right now, Your Honor. It scores a lot. It scores 72.5 points.
Points or months?
Points. In months, it's 33.37 months.
Okay.
It's a big downward departure.
Judge, I haven't had this case long enough to announce ready for trial on it, and I haven't discussed that with my client.
I mean, the case is only a couple of months old. And obviously, you weren't supposed to be handling this last week when we called it up first, Mr. Williams. So I don't have an issue if you want to continue it.
Yes, sir.
All right. So, Mr. Fletcher Gillette, we're bringing you back on February 24th at 1:30, so you don't have to sit here the whole Monday morning again.
Yes, sir.
But stay in touch with Mr. Williams or whoever they assign to your case if it's someone different, and we'll talk about it on February 24th.
Yes, sir.
All right, thank you.
Thank you so much.
Have a good day.
Jad Robert Franklin. Judge, Mr. Franklin is approaching. Judge, I went through the file on this. It looks like Mr. Gibbs was waiting on some medical records. We still don't seem to have that, so I'm going to move to continue it.
You okay with that, Mr. Franklin?
Yes, sir.
All right. February 24th, 1:30.
Thank you, Judge.
All right, we'll see you back that day.
Michael Gomillion. Judge, the state tendered a PTI offer for Mr. Gomillion. I need to go over that with him and the terms, and he needs to think about it. If we can set it for a miscellaneous day and have him come back on that date.
Which day? Any particular one?
Well, Judge, you know I've got a pretty significant trial coming up, so if we could maybe push it out a little after that.
Which trial?
Oh, that's the Norris trial.
Oh. That was one of my questions. I know we've got the stand your ground tomorrow.
Yes, sir.
All right, January 30th.
Thank you, sir.
All right, January 30th at 9 o'clock.
All right, sir.
Possible plea to PTI.
Iris Henson.
Are these to your cases now?
Yes, sir. Yes, sir. We are in my cases. This was passed, she was not in court on the 30th, and I explained to the court that my note said 12/21, so I thought she might have
She's here now.
gotten the wrong date.
Okay.
Judge, I need to go over the case with her. I think it's relatively recent. So I'll just ask you
Late
to continue it.
August.
Sir?
Late August was the start of it. All right, whose case is this for the state? All right, Ms. Turner, any objection to continuing it?
No objection.
All right, Ms. Henson, we're going to have you come back on February 24th at 1:30. Make sure you're here on that day. Make sure you talk to Mr. Williams in the meantime so you can work on your case.
So Ms. Henson's got warrant.
All right, Ms. Henson, they're going to take you into custody on that warrant.
How do I have a warrant?
That I don't know, ma'am. Judge, I've got Kelvin Holmes. Judge, I believe this was set for today so the state could try to contact the victim. I'd made a counteroffer of a misdemeanor assault.
No, wait, for what? For probation? What was your offer?
Well, I was trying to get it down. We hadn't gotten any real specifics, but this is one where I said that I talked with him and that he would plead to a misdemeanor assault on it.
Can you bring it back on Thursday or Friday and
I think I'm going to be here on jury reviews on that other case
Do
anyway.
Thursday, I'd like to not have too much on Friday because I've got some other things going on that day as far as meetings. I just don't want to go.
we place it on Thursday? It's fine for me, Your Honor.
I mean, if we have to put something on Friday, but we've already got obviously several there. I just don't want to put too many there if we don't have to because I may have to go to a meeting down in the Fort Walton Courthouse.
Can you come back on Thursday, sir?
All right, Thursday at 9.
Yes, sir.
All right, we'll see you back then, Mr. Holmes. Local one? No, was that Okaloosa?
That was Okaloosa.
Just can't find it. Go ahead, Mr. Williams. Oh, a new judge.
It's not.
Judge Kelly Hutto. Judge, Mr. Hutto's being evaluated for drug court. Also, in talking with him, I still have not had a chance to make a final decision on whether or not to do motions to suppress in the case.
Okay.
So I'm going to ask to continue it.
Any
We should have him,
objections?
he might already be in drug court by the time he comes up.
Any objections from the state?
No. Actually, there was there was uncertainty on my end as to whether this was set for trial. So we actually have subpoenas out, but
I didn't list it as trial.
I didn't see any note in the minute sheet, so I have no objection to the continuance. I'll cancel the
All right,
subpoenas.
February 24th at 1:30, Mr. Hutto.
Yes, sir.
Obviously, stay in touch with Mr. Williams if something happens with the drug court stuff.
Call my office, leave a number that I can pass along to Terry Henderson so that she can arrange for you to go to drug court. Okay, yeah, or you contact her. Jonathan Illy. This is Ms. Turner's. Judge, my last notes are that she was looking at the possibility of a misdemeanor and a year probation with the requirement that he clear his license. I don't think I've got an answer on that yet.
Yes, the state would be willing to plead count 1 to a misdemeanor and as charged for the remaining 3 counts. With court costs would be, I believe, $515 adjudication. The issue is there'd be 10 days mandatory jail because of the driving on suspended.
Would you be?
And
I remember now, we were still needing to talk about it because he's got a, will the court allow him to serve weekend jail time? He's got kids that he's trying to juggle, looking after in and among that, and he doesn't really have any family in the area.
Jail fine with that?
Yeah, do y'all do weekend jail here or 2-day?
I can't speak for the jail. Yes, we have had them do weekends.
There was an issue in Santa Rosa where over there they stopped doing it. I don't know if they are back to doing it now.
I just don't want to sentence them to something that they're not going to basically really want to honor.
Let's pass it then and everybody look into it and see if we can figure something out.
I know everyone has the idea if I say it, they have to do it, but I try not to have those types of relationships with our partners in the system. So, all right, so what do you want to put it on? Do you want to continue it?
How
or-
about January 30th? Is that one of our miscellaneous dates, Judge?
I think it's miscellaneous still, right? I mean, there's all sorts of things on there, so I'll call it
I'm sorry.
miscellaneous. January 30th at 9 o'clock.
All right, Judge, thank you. January 30th at 9. Yes, sir. William Gerald Jackson. Judge, this is a Child Advocacy Center case. It looks like it's ultimately going to have to be a trial on it.
I think
They-
it's my case, isn't it?
Is it?
I believe so.
It's a failure to register.
I thought it was.
But it's from 23. I think for a period of time, they were assigning those to the division attorneys.
That's what
so
I
think
heard
I'm
last
lucky
time, I
enough.
think. And then it went back. But I guess they didn't take them away from y'all. They just stopped assigning new ones.
Yes, sir. We've got to coordinate. It's a case where there's an expert witness. One of the issues in this case is Mr. Jackson's, his failure to register was unintentionally. He has documented memory deficits. We had him evaluated by Dr. Zeman. And I think we provided an employer of his some time ago that had written us about it. In any event, we're going to need to coordinate it with the expert. So I don't know when the court wants to.
All right. This is from September of 23.
Yes, sir.
So
A trial expert or sentencing?
Yes, sir. Or yes, ma'am.
Trial.
To testify about his memory deficits and that he would not be able to reliably remember all of his requirements. That's what the issue is in the case.
it's not a competency issue. It's a defense issue, a reliance on a mental health defense other than insanity. I think it's what it's typically called.
Judge, it's what, back when I was an EMT, we called organic brain syndrome.
Well, I understand that, but I'm from the legal standpoint is, just to make sure that everyone's on proper notice as to what's being done, because I think.
And I don't know if the state's going to want to depose Dr. Zeman or depose
Well,
the.
let's figure, is there a report that y'all have seen?
We listed provided the report in discovery. It's not something that's filed with the clerk, though.
I just want to make sure that they're on proper notice and everything's done the way it's supposed to be done.
I believe that I did review it, but I was under the impression it was going to be used for mitigation at more of a sentencing than for purposes of trial. So I will have to take a fresh look at that.
All right. So I'll put it on 2/24 for potential trial next cycle, but I'm not going to continue again unless it's an expert issue as far as setting dates.
Yes, sir.
This case is just way too old to be.
Yes, sir.
Still, I mean, we're talking about 15, 16 months old on a third-degree felony.
All right, Mr. Jackson, I'll also need to prep you up for that trial, okay? So make an appointment to see me towards the end of things, okay?
February 24th, 1:30.
Yeah, so I'm going to say, call and make the appointment around February 1st. Benjamin King. Judge, just so the court's aware, Mr. King did show up at my office at 9 o'clock Friday as he was supposed to. Unfortunately, because of Ms. Sandler's schedule, we had to do the deposition at that point. I have spoken with him briefly today. My notes are to continue it for him to resume the depositions and expect a trial next time.
We've got to get the depositions rescheduled, I think.
I think there was one witness, Ms. Jesperson, that didn't show up. I will try to reschedule her. I don't anticipate she's going to be cooperative, though. But I'll try rescheduling her.
And make sure I understand, you're talking about showed up for the deposition for what?
On this case, Ms. Jesperson was the civilian in the vehicle with him, and she was served substitute service, but failed to appear. So normally I'd try to reschedule, but honestly, I don't realistically think she's going to be cooperative and come in.
And who's doing the deposition? You or?
It's my deposition, Judge. She's listed as a state witness.
Their witness. Okay.
Yes, sir. But I don't know that she's been able to get her in the office either.
No, and we had made an amended offer to plea to F3L1, fleeing and eluding with lights only.
Yes, ma'am. I went over that with him.
Okay. We can continue it and set it up for next cycle, Judge.
All right.
That's fine, Judge.
February 24th at 1:30, Mr. King, stay in touch with Mr. Williams.
All right.
See you back on that day.
Looks like we did Holly Mason already. Cindy Mullins. Judge, I think Ms. Mullins, we got some emails from your judicial assistant. I think she contacted your office.
Apparently she contacted my office, but like by email, like 4 o'clock in the morning yesterday. I think what happened was she wasn't here on last week, and we kept it for today, and now there's some issue why she couldn't be here today. I try not to read those things unless it's absolutely necessary, so I'm assuming y'all received them at this point.
Yes, sir. And we had communication with her before. It really boils down to insufficient time. The waivers require her signature. And so with things being set on short dates, it's been, when we found out at the last minute she was not going to make docket day because she had car issues, she's moved to another state, can't get over here for that. It's a PTI fail-out, so it's not something that would go to trial. She's basically going to have to stand before the court for sentencing. But it's also insufficient to file the proper motions, to do a Zoom hearing, et cetera, et cetera, et cetera. She's amenable to a Zoom hearing. That's what she's wanting to do. But we've got to dot our I's and cross our T's on this. So.
What type of hearing?
Well,
Wait,
that's a good point. I mean,
because she's coming back on for sentencing, it's not going to be by Zoom.
So we would ask, I mean, presumably we'd have to set it for a hearing on the PTI violation, but she's already entered a plea, so as soon as we can establish that, we can set it for sentencing. So the state would ask to have that evidentiary hearing set.
What date do y'all want for that?
Judge, I live to serve.
I don't mind a full continuance. Judge, I think we have plenty to do.
All right. This is what I'm going to do, Mr. Williams. I'll do the 224 at 1:30, but she needs to be present, either in person or a Zoom request has to be done, so we can talk to her. None of this, like, I'm not saying this is on you, Mr. Williams, but she seems to not show up for things and then wants to get excuses at the last second, and that's what's causing the issues. I'm giving plenty of time to resolve that.
Yes.
Obviously, if she finishes up what she's supposed to do, that could change the state's mind on what they want to do. Certainly would have an effect on what I ultimately do if she's to be sentenced, if she's actually completed everything, so she might want to work on that in the meantime.
Judge, that's all the out-of-courts that I
Custody.
have, and I know the courtroom is empty.
Okay.
I got a Pop-Tart, so bring them on. I've gone low twice this morning.
Okay.
Okay, Mr. Higgins. Judge, he's got a case over in Santa Rosa. I need to deconflict with what they're doing over there. I'm just
The
looking
issues
at
that
the
came
rest
up
of my
last time, was
notes.
there some newer cases coming?
On Mr. Hagan's?
Yeah. This is 23 CF 2295, right?
He also, yes, Your Honor, he also has 24 CF 2607. And that's a possession of controlled substance, 2 counts information.
It looks like on that one, he was rearrested. Well, actually, it may be on the original. He was rearrested 7/12 of 24. I think there'd been a failure to appear on this one back in November 9th. He was incarcerated, and Judge said the bond forfeiture was set aside upon motion by the bondsman about him being incarcerated. Doesn't look, though, like
He
the
already
motion
has
was
a
served on the
pretrial
state.
for February 24th on the new case.
Then let's, that's what I
24
thought, let's
CF.
have him track.
2607. All right, February 24th. Actually, it's, since he's incarcerated, it'll probably end up being February 26th at 9 o'clock. But I think we're still announcing them for the 24th.
I know, Judge. But I figure we should keep in mind that when you say the 24th, if he's incarcerated, it's actually
It'll be
gonna-
the 26th.
Right. Okay, that's fine.
I'm just trying to make sure that, especially the private lawyers know how that works. I guess I had that happen to me once when I was in Santa Rosa County. I went up there and they're like, well, you're not supposed to be here till tomorrow. I'm like, well, there's nothing in the notice that says that, so I want to just make sure we're telling everybody that, so.
Yes, sir.
So February 24th, but we would expect it to be the 26th at 9 o'clock.
All right, Judge, thank you very much. Okay.
The concern is if someone bonds out between now and then
That's-
they're supposed to be here on the 24th.
Madam Clerk, are you showing him coming in to our court on the 19th? He's asking about it. I think you may be thinking of your Santa Rosa case. Okay? Judge, my plan on this case is to continue it.
All right, it's first time up, I think.
Yes, sir.
State.
No objection, Your Honor.
All right, Mr. Harrison, based on the request, we'll continue to February 24th.
Thank you, Judge. Not today. Okay. Not today, sir. I'm sorry, I thought that was Henderson.
That was Harrison.
Harrison. Okay. No, it doesn't. It just means that I scrolled further than I thought I had. All right, Judge, this is Zachary Henderson. This one I was planning on asking the court to continue.
I don't have any objection, Your Honor. He wasn't set.
I understand, but what are we doing with it? I mean, the newer case is from April, the older case is from, is that a VOP?
Judge, I'd have
It
to
is.
file.
It's got a VOP, yes.
And again, I apologize for that, but just for some reason, some of these are showing them as VOPs and some of them are not when they are.
Yeah,
I just, that's why I'm asking the question.
Yes, Your Honor.
So
No
it's an
problem.
old case, but because it's a VOP. All right. What do we need to do here at this point, Mr. Williams? What's being done? This case is 8-9 months old already.
Judge, he's facing a 5-year mandatory minimum. There were videos that we couldn't get in originally, body cam videos. The allegation is that he assaulted a law enforcement officer with a vehicle, and originally the only video we had was where the warrant was served on him. Okay. Those videos have now been provided. I need to look at them, and I need to go over them with him.
Okay. All right, February 24th.
Thank you, Your Honor. That's fine.
All right.
Mr. Horn.
Judge, we need a date certain on the motion to suppress for this. It's been kind of bounced around.
soon do you want?
Judge, I drafted the motion some time ago. It's a warrantless search, so
Has it
the
been
burden will
filed
be on
yet?
the state. It has been, Judge.
Oh, I see, back on December 4th.
Could we set it maybe for February 6th? It's a miscellaneous date that we have.
Do we have a date earlier than that, but not conflicting with the Norris trial?
The 30th, but I don't know if we have, I have a few things set already, I believe, Your Honor.
This will require evidence and testimony, so what we used to do was those would get set in the afternoon. When I brought that up last time, the state objected, so we're deferring to you how you want to hear those. If you want to hear the contested ones with evidence and witnesses in the afternoon, we can set them that way.
I think it's better to do that. The problem is I think I've got at least 3, if not 4, different cases that are set the afternoon of the 30th. I don't mind putting it there, but I don't know how long the cases are going to take because I don't know the cases like y'all do.
If there's room then on the 6th, go ahead and put it on the 6th.
PM, February 6th in the afternoon, Your Honor?
Yes.
Okay, that's fine.
All right. That's going to be 2:30. Because
That's
the
fine.
arraignment's at 1:30 and then 2:30 docket.
Yes, that's.
There's only 2 there now. I'm sorry, 2:30. Mr. Hudson.
Morning, Your Honor.
Morning, or, well, afternoon now.
Good afternoon, Your Honor.
Judge, give me just 1 second.
I feel like it's going to be good evening soon enough.
First, Judge, I talked with Mr. Hudson. He's got a defense to this. Originally, we've been talking about a trial, but we talked last night about the possibility of him accepting what I understand to be the state's offer, that no set amount of time, it would be up to the judge, but you would stipulate that he qualifies for a downward departure. Have I got that right?
Yes. My intention, I didn't make an offer. My intention was to have the judge decide what would be a fair sentence. I noted that on similar charges earlier this year, he was given a downward departure, and I would stipulate to that so that that would open up more possibilities for Your Honor to.
Sure, I would understand what that means. Stipulating to a downward departure is that he's eligible for one, but not that I'd have to give him one. All right. I'm not saying I wouldn't. I just want to make sure I understand what y'all are saying.
Opens up more options.
He had inquired, and correct me if I'm wrong, Gary, about whether or not the court could sentence him today.
I don't know anything about his case.
All right. So it looked like it would be all right, Judge, I think we're going to, ultimately, this case is going to need to go to trial unless things change.
Well, Your Honor, I'll go ahead and say the court's time. I'll go ahead and plea out to the mercy of the court.
But I'm not making a decision today because I don't know anything about you. So I'd just be trying to quickly learn as much information as possible and determine whether or not you're going to prison. You want me to probably have a little more information than just reading a report or hearing what the lawyers have to say. He needs to put on a case.
Yes, Your Honor.
All right, Judge. I don't know whether or not we're going to be able to do it this time. I think probably at most it'd be a half-day trial, and it looks like he may do otherwise. When would the court be in a position to take a straight-up plea? I'd get him to sign a plea offer that just says straight-up plea, and then be sentenced.
Are you going to waive a PSI?
He's not going to qualify for a PSI, Judge. Well, I say he won't qualify. He's not required. He's been sent to prison before. So he's not a first offender or first-time felony offender. You would not be required to do a PSI on him.
much time do y'all think you need to give me what information you want to give me? To me, sentencing is not something I should be reading something on the fly and then send, this is the rest of your life potentially. It's something I need to read in advance. I'm not saying you have to give me 20 pages of argument and everything, but I need usually something in advance before I make a decision.
Judge, I tell you what, give me, not for a hearing, but give me the 30th, and I'll go out and talk with him some more, and maybe see if we can get this kind of nailed down.
I know you've basically agreed that a downward departure is potentially there, Ms. Turner, but what does he score otherwise?
75.5 points or 34.8 months. But Mr.
Again, I don't know anything about it other than I tried to read the arrest report while we're sitting here, but I just don't have the time to do those things. And,
Yes, sir.
When I'm making a decision if someone's going to jail or prison, I'd like to know a little bit more and have some time to read.
Yes, sir. I think that's probably going to be our best bet. I should have a firm decision and maybe even a sentencing memo available for the court by that date, and at least we can get the ball rolling.
So the anticipation is to be prepared for you to do the sentencing on the 30th.
So he's going to enter a plea and go straight to sentencing at that point, as long as y'all have sent me something in advance?
I serve at my client's direction, Judge. I think he's got a good defense this time.
I'll take it to trial.
Let's just bring you back in on the 30th, okay? And then if we need to, maybe we can set him off for the 6th. That'd only be a week away, and sentence him then.
All right, January 30th at 9 o'clock.
Thank you, Judge. Okay, Brian. Judge, we've got a plea agreement in this case. I just need to pull it out. Now, the form's going to look a little unusual.
Who is this again? I'm sorry.
Rodney Hutchinson.
Okay.
He had a number of different counts. A number of them went federal, and the state already dismissed those. What he's pleading to are the remaining counts. So what's he going to do? 5 years DOC, but concurrent with your federal sentence. 5 years and 60 months.
And I'll be serving it in federal.
Right. May serve in federal facility.
May serve or will serve?
Well, he can't order the feds what to do.
Right.
What he's saying is the state of Florida gives permission for you to do that.
Correct.
Okay? So, signed somewhere up in there. I mistakenly started to sign on your part. Let's say right there, maybe. All right. Do you mind if I date that for you? There you go.
You didn't check adjudication, but since it calls for
Yeah.
DOC. Okay.
Yes, sir, adjudicate. And PSI is not required.
Is the 2020 case, is that a VOP?
Don't believe so. I think that's an old failure to appear, Judge. And this case is old because he's been in federal custody, so we've been having to pass him each month.
Mr. Hutchinson, did we ever have a case together on something else?
You look.
Your name just sounds familiar to me.
Yes, sir. I remember seeing you, probably family.
Oh, no, you were in a dependency case, I believe.
Yeah, DCF case. Yes, sir.
That's where it comes from. All right. I remember it now. All right. Raise your right hand to be sworn. Do you swear or affirm the testimony about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your name and date of birth, please?
Laudell Hutchinson, 9282.
Okay. You're here in 20 CF 1752, which is one count dealing in stolen property, second-degree felony, and then 24 CF 406, driver on license suspended, third conviction, possession of controlled substance, resisting without violence, possession of drug paraphernalia, attaching an improper tag, DUI, grand theft auto, leaving the scene of an accident. The agreement I have shows it'll be time served as to each of the misdemeanors, and then for the remaining counts, 5 years DOC. Is that what you understand it to be?
I understand it to be, I already got 92 months fed, so I was getting that.
What we're saying is be
fed.
concurrent with your federal sentence, that you can serve your sentence in the federal facility, but that's, Mr. Williams somewhat told you, I can't tell them what to do. They don't listen to me.
Right.
So.
Correct.
All right, is that what you want to do today?
Yes, sir.
Okay. Have you gone over this plea and sentencing agreement with Mr. Williams?
Yes, sir.
Did you have enough time to go over it with him? Did you need any more time to go over it?
No, sir.
Did you understand it?
Yes, sir.
Did you read all the terms of it and sign it?
Yes, sir.
Okay. Has Mr. Williams answered all of your questions?
Pretty much, yes, sir.
Well, is there something he didn't answer? I don't accept equivocal answers when you say pretty much or yeah, kind of.
Right.
I'm going to ask you again what you mean by that.
Right. Yes, sir.
Okay. So he answered all of your questions.
Yes, sir.
Are you satisfied with his advice and representation?
Yes, sir.
Are you under the influence of any alcohol, drugs, or prescription medicines?
No, sir.
All right. Do you have any mental health issues or concerns that could impair your ability to make this decision today?
No, sir.
Anyone promise you anything in return for entering this plea?
No, sir.
Has anyone forced, pressure, or threatened you in any way to enter this plea?
No, sir.
And you understand there won't be a trial of any kind if you enter a plea?
Yes, sir.
So you're giving up all your trial rights that you read about in this agreement?
Yes, sir.
And you understand you're waiving any potential defenses that you may have had?
Yes, sir.
And what is your plea?
No contest.
All right. I'm going to accept your no contest plea as freely, voluntarily, knowingly given in the misdemeanor counts, which are the resisting. So that's in 24 CF 406. That's count 6, count 7 paraphernalia, count 8 attaching tag not assigned, DUI are all basically time served. What about all the DUI sanctions though?
Judge, the position I've always had is that you can D6 the license for those.
But I got to sentence them on all those things. A DUI requires 12 months probation, impound, driver's license suspension, community service. All those things have to be on here. Even if I D6 them, they still have to be on there. I don't think I have any ability to just say, let's give them time served on a DUI. It's an illegal sentence.
It's only the count, the DUI count. I can dismiss it, Your Honor. He's gonna go to prison.
All right, state's announcing a dismissal of count 9, which is the DUI. All right. And so we'll strike that from the misdemeanor counts that were time served. There's also the leaving the scene count 12, which is a misdemeanor that would be time served. As to the felonies, which is the dealing in stolen property in 20 CF 1752, and then also drive while license suspended third, which is count 3, count 4, possession of paraphernalia, possession of controlled substance, and then count 11, grand theft auto. Those are going to be 5 years Department of Corrections, concurrent with his federal sentence that he's currently serving.
Yes, sir.
Okay. You'll be allowed to serve your state time in that federal facility. Court costs of $515, $100 cost of prosecution, $150 PD fee, be adjudicated on all cases, all counts. Anything that I've missed?
Nothing I'm aware of, Judge.
And that's the state's agreement.
It is the state's agreement.
Okay, and then this is a guideline sentence.
Yes, Your Honor, it is. It's not a downward departure.
All right, Mr. Hutchinson, you're gonna have to be fingerprinted, and you have 30 days to appeal.
All right,
Yes, sir.
Good luck.
All right, thank you.
No problem. Judge, this is David Wesley Johnson. I spoke with Mr. Johnson. We've got a counteroffer to make to Ms. Turner. Ms. Turner, would you consider meeting us halfway and doing, say, 18 to 24 months, somewhere in that neighborhood?
I'm not gonna make a decision right now on that, but I'll take it under advisement.
Yeah. Judge, I anticipate, since he's got a VOP that involves the same thing, I anticipate we'd be doing a VOP trial first anyway. Let's pass him to a VOP docket.
Wait, this is David Wesley Johnson?
That's correct, Judge.
All right, so the VOP is the 23 case?
Yes, sir.
And 24 is the false imprisonment and battery?
Yes, sir.
Okay. All right, so what would you like to do with it, Mr. Williams?
Let's pass it for a VOP date and see if we can get it resolved.
January 30th,
Thank you, Judge.
9 o'clock.
That'll give the state a chance to talk with the victim as well. Yeah, I'll come see you before. Okay.
Nathaniel Jones.
Judge, I've got Nathaniel Jones. He was given his choice between a probation offer and 1129 County Jail. He wants to do the probation. This would be a plea to the lesser offense of attempted aggravated battery. I sent an email over to the state because I noticed that he has no prior felony cases. His score sheet's all misdemeanors, and asking if they would agree to a withheld on it, but I haven't. They would have just gotten that.
I responded, I said it's fine.
Okay, all right then. All right, Judge, we have an agreement then. Okay.
Yeah, I mean, I'll give you the score sheet after.
Okay. Thank you very much.
All right, Mr. Jones, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name, date of birth?
Daniel Paul Jones, 11/30/1988.
Okay, and Mr. Jones, you're here in 24 CF 1683, currently charged with aggravated battery, which is a second-degree felony, punished by up to 15 years in state prison. I've been handed a plea and sentencing agreement for 3 years probation with a withhold. Is that what you want to do today?
Yes, unless it can all be dropped, but yeah.
Well, I'm not doing that because I haven't been asked to do that officially as far as anything. So, but that's the sentencing agreement y'all have come up with.
Yes, sir.
As you still want to do today. Have you gone over this form with your lawyer, Mr. Williams?
Yes, sir.
Has he answered all your questions about it?
Yes, sir.
Did you understand it?
Yes.
All right, and has he answered all of your questions?
Oh, yes.
Mr. Williams, are you satisfied with his advice and representation?
Yes.
Are you under the influence of any alcohol, drugs, or prescription medications? Do you have any mental health issues or concern?
No.
Anyone promise you anything in return for this plea?
No.
Anyone force, pressure, or threaten you in any way to take this plea?
No.
You understand by entering a plea there won't be a trial of any kind? And you'll waive any potential defenses that you may have had? You understand that? All right, and did you read all about all your trial rights that you'd be giving up in order to take this plea?
Yes, sir.
Any questions about those? All right, and what is your plea?
No contest.
All right, I'll accept your no contest plea is freely, voluntarily, knowingly given. Withhold adjudication to the lesser included of, what did y'all call it, attempted aggravated battery?
Yes, sir.
All right, 3 years probation, batter's intervention, ECLC or similar for substance abuse or alcohol abuse. All right, he says reserve 90 days for restitution. So am I ordering restitution and reserving as to the amount, or am I reserving on the issue of restitution?
Reserving on the issue of the amount.
Okay. So I'm going to order restitution, 90 days I'll reserve for purposes of determining what that amount is, no contact with the victim unless that victim requests contact and a sworn witness statement that gets filed with probation. Court costs, 615, 201, 151.
It'd be
817 total. $100 cost of prosecution if that's not included, $150 public defender fee and application. I'm going to just cross through this where you've got kind of the or with the alternative offer of the
Yes, sir.
1129, just so someone doesn't look at that and think he's supposed to do 1129 before this probation starts. All right. Is this a guideline sentence?
Yes, Your Honor.
Okay. All right, so I'm showing 36.8 points.
Yes.
All right. All right. Mr. Jones, you're going to talk to probation today before you leave. Fingerprints in 30 days to appeal. Anything else?
Nothing, Judge.
All right, thank you, Mr. Jones.
All right, sir.
Waive cost of supervision, it wasn't in there and I forgot it. Thank you, Mr. Berry.
Robert Hume,
We've got two different Robert Jones. Okay. Appreciate you bringing that up so I don't throw them together here.
Judge, I've got a note to have my secretary schedule deposition. He picked up another second case. I believe, I don't think those two are tracking yet, although I can look at the file and tell you for sure.
I can pull it up.
I'm still working on trying to do this paperless thing.
Which is funny because I'm usually the paperless person, and with how fast this has to go sometimes, I need paper.
Is it a VOP? Oh, for arraignment? All right. Judge, I'm going to want these two to track together. If you want to set this one on for Thursday as well, and then we'll put them
Right.
both on, or if you want to just pass it to the 24th.
Thursday, January 9th at 1:30 is his arraignment day. We'll just put this one with it. Oh, you'll put it at 9 since he's here? Okay. 9 o'clock then, Thursday.
I'm sorry, what day did you say, Judge?
Thursday, the 9th. He's got an arraignment day that date for his new case, so we're going to put them together on that date. I'm not sure what we're going to get done that date, but it's new charges of trafficking fentanyl, possession with intent, fleeing to elude, cocaine, tampering, felony marijuana.
Well, we could, yeah, Judge, let me just do that then. I'll go ahead and arraign him on the new case since an information's been filed, and he can come off the docket. What are we setting on right now, 224?
224. Technically already set for that. All right, so plea of not guilty will be entered as to the information in 24 CF 2735. So we can take that off of Thursday, put both of his cases on February 24th.
Yeah, that would be fine, Your Honor. They'll be mine, both of them.
Okay. At the information.
On the new case.
Record, Mr. Jones has been handed a copy of the information in the 24-27-35 case.
Thank you, Judge.
All right. All right. We'll see you back on February 24th.
All right, sir.
Or 6th if you're still in custody. Okay.
Judge, my notes are to ask the court to pass this for a miscellaneous day for me to try to get it worked out. He's got a pending sentence in, I think, Mississippi. So we're going to want to try to get it finished up, but
This
I'm
is all
still working on
VOP,
it.
is that right?
Yes. 2 cases from 2019.
Judge Gontarek at the VOP, some VOPs on this docket.
That's okay. I just want to make sure that's what we've got so we know where to put it next.
Yes, sir.
Are we putting it for an evidentiary hearing, or you just want to come back to see if y'all can work it out?
I just want to see if we can get it worked out within the pending sentence over there. I don't know, there's a lot of point in having a
January
hearing on it.
30th at 9.
I'm sorry, Judge, you said what?
January 30th at 9 o'clock.
Thank you, sir. Okay.
Charles Kemp.
Judge, we're trying to find a dual diagnosis.
Make sure we're announcing this is Charles Kemp, 24 CF 1490. Go ahead.
Yes, sir. Judge, at this time, we're trying to find a dual diagnosis facility so that we can offer that as a sentencing alternative.
Are we expect it'll be a plea?
Ultimately, yes, sir. I am going to file a reciprocal. We got a communication from his mother disputing the ownership of the property. But I'm hoping to get it all resolved.
Any objections from the state?
No, Your Honor, no objection.
February 24th.
Thank you, sir. Okay, Mr. Kemp.
Derek Lewis.
Judge, we've been trying to get DNA done on this one to resolve the case. My understanding is that FDLE has worked through that, but they want a sample from him, and I believe Ms. Leone was looking to have the buccal swabs done on Mr. Lewis today.
Yeah, if possible, Your Honor, that's what we need.
Okay. And go back and do that at the jail? Or do you
Usually they go ahead and swab them here and, no?
That's correct, yeah, they have to.
So they'll go to the jail and get it from him?
Okay, but we'll just go ahead and make sure the record reflects our consent to that. And let's get that done so we can get a resolution, Judge.
The only thing, Your Honor, I want to mention is that with the DNA and the backlog of cases, this is going to take another long amount of time. And for the court record, the state does not need this DNA result. So it's upon request of the defense.
That's correct, Judge. We believe the DNA is going to exclude him as a contributor. He expresses that he did not touch the weapon that's alleged.
And the state is agreeing, is actually agreeing with that statement, Your Honor. So we agree that probably we're not going to find his DNA on it, but there is a reason, so.
So as far as the time it takes, that he understands it may take a little bit of time.
Well, Judge,
I mean, this case is over a year old already.
Exactly, Your Honor.
And we've been trying to get the DNA for months now, Judge.
What do you mean, get the DNA?
I filed a motion to have this done months ago. FDLE's policy, apparently, is that they don't do DNA unless there's a death involved. They're not testing drug paraphernalia, for example, the container that the cocaine was in, something like that.
Let's stick to the DNA for this purpose.
For this purpose is to show that he didn't touch the knife. Our allegation is that he didn't stab this lady. I don't want to try it too much here today, but that he did not commit this offense. He didn't touch the knife.
But you're saying you asked for this to be done in the past?
Yes, sir. Yes, sir. I brought a motion to, the state stipulated to it at the motion hearing, and we've just been trying to get it done ever since, and every time we come up to court, nobody's tested it.
Is there an order that's been signed?
I don't know if the judge signed an order since the state stipulated to it, but I had filed a motion, and we had it set for a hearing.
The motion was filed back in April. When it comes to stuff like that, you should always have an order that has a judge's signature on it. Otherwise, I can't imagine FDLE or any other agency is going to do something based on clerk's minutes and things like that. So
Well,
even if it's a stipulation and it's announced, I think it's always good. Here's the order, have the judge sign it and get it off.
I think what the state was basically was, okay, well, we're going to do it, et cetera, et cetera, et cetera. They were going to do it on their, I don't guess it matters at this point. I'll get an order from now on, Judge.
All right. I think it's just better to have it that way, especially because, as we know, the state has certain responsibilities and implied kind of authority over FDLE, but at the same time, Miss Leone can't just call up Tallahassee FDLE and say, do this, and they do it. If it's not happening, what I would say is you need to file something, get in order, get it moving along. Otherwise, this is where we end up.
Yeah, just for the court's knowledge, this is not that it's taking long because there was not an order of the court. It's because, for instance, in this particular case, they had to subcontract the DNA analysis to another lab somewhere else because they're overworked, and I'm just saying that I don't think we need to wait another year to get this because the state does not need that DNA. I can go forward without that.
The question is not whether the state can go forward without the DNA. The question is whether he can get a fair trial without the opportunity to provide this evidence.
Oh, I understand that part too. I just want it to go faster for his benefit.
Yeah, but he can seek that DNA analysis himself, not the state. It's a favor that I agree to it.
Give me the evidence, put it in my hands, and I'll go find somebody. And that'll screw up your chain of custody.
All right, back up, Mr. Williams.
What's wrong?
But here's the thing.
I hear this all the time.
Mr. Williams, I understand. But if you feel the state's not doing something that they're required to do, then you file a motion. Then we come in here and I tell them to do it if it's something they're obligated to do. Otherwise, DNA evidence can be tested by an outside lab, right?
How do I get possession of it, Judge? And I'll tell you, Magda Clanton told me 30 years ago they don't test for defense lawyers. Back when she was over DNA.
Well, I don't know what's going on 30 years ago, but I can tell you when I was a defense lawyer, there was plenty of times I had things like vials of blood sent halfway across the state to be tested by other labs. It can be done, but it has to be done. You just can't say, I hope it happens. If you want to get this stuff tested, you have to push it. If they're not turning over something, and we've got a Brady issue, we've got a Richardson issue, we've got even a Youngblood issue, if they're not testing things that they should have or they're not keeping evidence that they should have. I'm not saying any of those things have happened in this case or any other, but a motion has to be filed. And then we come into the court, and then I say, give me all your evidence, give me your argument, and I'll make the decision as to what should have happened or what should happen going forward. Otherwise, y'all just sending emails to each other, it hasn't gotten us anywhere.
Judge, we had a hearing
With no order, Mr. Williams, that's my point.
Yes,
There's no order. And even if it's stipulated, there should be an order where the judge signs it, says this has to be done. That's what gets things done. And I'm not trying to be critical or anything like that. I'm just saying, if it's not working, we have to try something else.
Yes, sir.
What would we like to do with Mr. Lewis today? I'm assuming the only thing we can really do is put him on the February 24th date and see if progress gets made in the meantime.
Yes, sir. I'll draft an order and send it over for the court. I think that the court has sufficient evidence in front of it based on the
They
statements
stipulated
made.
to it. But if Judge Gontarek was the one that heard that at the time, just have him sign it. If that can't get done, I'll take a look at it, but I can't just sign orders based on hearings I wasn't at. So just send it over to Judge Gontarek and see if he can get it done quickly. If that doesn't work, contact my office, bring it up the next time we're here.
That's fine, Your Honor.
Yes, sir.
All right, thank you. Thank you, Mr. Lewis. February 24th.
Judge, this is a trafficking case with a 7-year mandatory minimum.
Who is it, though?
I'm sorry, James Bernard Marshall.
Okay, gotcha.
This is a trafficking case with a 7-year mandatory minimum. At this point in time, we do not have an FDLE report, so I'm going to move to continue.
No objection.
All right, any issues with that, Mr. Marshall? February 24th.
Is that it?
That's it, sir. Yes, sir. This
Here.
Oh, what about it?
Just 1 second.
With the first degree misdemeanor, we can't go less than 9 months. 9 months is a little. As long as we get it concurrent, I'm good with that. And July 11th.
Judge, this is actually a plea.
Who is this?
This is Randy Mathias.
Okay.
It's actually a plea to a first-degree misdemeanor petty theft.
Okay.
Based on the language in the information.
And the count 2 trespass.
Let me get your signature up there.
We didn't agree with the continuance.
Oh, yeah. I will. All right, Judge. Mr. Anderson.
was initially charged with the misdemeanor, then it was filed as a felony, and then now it's a reduction from the felony to the misdemeanor.
Judge,
And with all the direct file KPS, and that's why I've got issues with credit for time served, correct?
yes, sir.
All right, pronounce your last name for me, sir.
Matthias.
Matthias. All right, Mr. Matthias, can you raise your right hand, please? Do you swear or affirm the testimony about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name as well as your date of birth, sir?
Randy Joel Matthias, March 11th, 89.
All right, and you're here in 24 CF 1950. You're currently charged with felony petty theft, third-degree felony, and trespass, a second-degree misdemeanor. I've got a plea and sentencing agreement to reduce the felony petty theft back to misdemeanor petty theft. Is that what you want to do today? What do you mean you guess?
Yes, sir.
Okay. I'll just give you a fair warning. If you give me an answer that's not quite positive one way or the other, I'm going to ask you about it.
Yes, sir.
I'm not trying to be critical of you. I'm just going to make sure you understand what we're doing here today. All right. So this calls for 270 days in county jail and credit going back to July 11th. Is that right? Okay. That's your understanding.
Yes, sir.
Did you go over this document with Mr. Williams?
Yes, sir.
Did he answer all your questions?
Yes, sir.
Did you understand it? Do you understand that you're giving up your right to a trial by entering a plea? Do you understand you're waiving any potential defenses you may have to these charges?
I do.
And do you understand you're giving up all your trial rights that are mentioned in this agreement? Are you under the influence of any alcohol, drugs, or prescription medications? Say again.
I am not.
You're not. Okay. And do you have any mental health issues or concerns?
No, sir.
Anyone promise you anything in return for this plea?
No, sir.
Anyone force, pressure, or threaten you to take this plea?
No, sir.
All right. And what is your plea?
No contest.
Guilty, no contest, or not guilty?
Contest.
All right. I'll accept your no contest plea to the misdemeanor petty theft and the misdemeanor trespassing as freely, voluntarily, knowingly given. Adjudication as to each count. Count 2, which is the trespass, is time served. Count 1 is 270 days county jail with credit since July 11th, 2024. They're run concurrently with any other sentence that you're serving. You may serve these in DOC. Do you have a DOC sentence coming?
I do.
Where's that from?
What do you mean, sir?
What county?
Is it another county?
This is Okaloosa.
Is it
Okaloosa
South
County.
End? Or is it South End, or is it just a case we've already resolved here?
It's already been resolved. here.
Okay. All right. 515 in court costs. Well, wouldn't that change because it's a misdemeanor? 270. 270 in court costs. $100 cost of prosecution, $50 application fee, $100 PD fee. All right. Any other questions?
Now, that is run concurrent with the
Concurrent.
14 months DOC.
Whatever, concurrent with whatever other sentences
Yes, sir.
you've got.
Okay.
Yes, sir.
Understood.
All right. It's a misdemeanor, so I don't need a score sheet. You have 30 days to appeal, Mr. Matthias. Good luck to you. I do need your fingerprints. Thank you, Steve.
Judge, Mr. McDonald, I'm showing him as having a new charge. He was just rearrested. I was originally going to pass this to the next miscellaneous statement, but he's also advised me just now that he's being considered for a specialty court. What we can do is we can pass it to a miscellaneous date, say 1:30 or 2:06, and I can look into it and try to get more information on what's going on.
Your Honor, it's the homeless thing with Bridgeway and Post and the Okaloosa County EMS, and for the eligibility for that program, which is a 90-day program for people with drug problems that are veterans and are homeless.
You talking about vet court?
No, sir. It's they came to me like 4 or 5 days ago at the county jail, EMS, Post, and Bridgeway. Those three agencies have combined together to help veterans. It's a new program. I was unaware of it until the other day, but they set me up for an evaluation for eligibility.
What's the name of the program?
I guess Bridgeway is running it, Your Honor. I'm not for sure what it is. I know I got a card that says post on it, community, and the Okaloosa County EMS. There's a veteran there that's a Marine, and he's helping the community too. They both interviewed me the other day at the jail for homeless veterans.
You don't know the people's names that you talked to?
I should have brought the cards this morning, but I didn't do that. I'm sorry.
Ed Rivera?
Maybe so.
If you're considering this a program,
Yes,
you should
sir.
probably listen to the information and know who you've talked to so we know what you're
Well,
talking about.
the EMS officer's name was Kendall.
EMS?
Yes.
Like emergency medical
Yes.
service?
Yes, sir.
Oh.
Post and Bridgeway.
Okay. What date would you like to put it on?
Judge,
It's already
I-
set for felony plea on the 30th of January and pretrial on February 24th for his new case. No information's been filed yet, but vehicle theft, criminal mischief, petty theft, escape, resisting, disturbing the peace.
Yes, sir. That was the case I was referring to. Let's leave him set then on the 30th, and I'll try to learn more about this other program.
All right. January 30th at 9 o'clock. I'd like to know about the program too, if there's something available.
Yes, sir.
Yes, sir.
Thank you, Your Honor.
All right, thank you, sir.
Mills.
Judge, I've gone over the case with.
Tyler
this is
Mills,
Mr.
24
Mills.
CF 2340.
I've gone over the case with my client. He'd like me to depose the officer that conducted the stop and said that he was fleeing and attempting to elude, so I'm going to move to continue it for that purpose.
Any objection?
There's no objection, but we are reissuing our 10-day letter seeking a subpoena ducis tecum in the event that that we might find a blood alcohol level. So currently, the offer would be to plea as charged, so with the continuance, that gives the state more opportunity to do that.
Yes, ma'am. I've explained that.
Has he been served with a 10-day letter?
We served one, and there was an objection from Mr. Williams, and we had some back and forth where we proposed more narrowing language.
Is this
I
the one that
believe
got sent to me back in December, or was that a different case?
No, I think it was longer ago than that, Judge. That initial one was served mid-November. I don't know the status of the second one. We had agreed upon the language, so
Yeah,
I'm not
we'd agreed upon the language.
I'm not anticipating objection, but we'll have to wait for the time period all the same.
All right, so you just want February 24th?
That's fine, Judge.
All right, February 24th, your next pretrial date.
All right,
Thank you,
Mr. Mills.
Found the one I was talking about, but I can't open it, so. All right, it says William Moore?
Yes, sir.
All right. 24 CF 2085.
Judge, this is another one that could perhaps be set on a miscellaneous date. Basically, I just want to spend some more time with the state attorney and try to negotiate her down a bit.
Is that Ms. Turner? No. Or Ms. Leone?
No, that'd be Ms. Leone. Also, I need to get my investigator out to let him listen to the depositions.
Listen to the depositions? Is that what you're
Yes,
saying?
sir. All the civilians did not appear, or some of the civilians did not appear from the depots, but the officers all did, and I wanted to at least hear what they had to say.
Okay. I'm sorry, I misunderstood you. When you said you have the investigator, so your client can listen to the depositions?
Yes, sir.
All right. All right, what date would you need?
A little bit later, Judge. I'm going to say more like 2/6. I think we're already loading up 1:30 pretty high.
All right. February 6th, 9 o'clock.
Thank you, Judge.
Thanks, sir.
All right, sir.
Jonathan Murphy? Okay. 24 CF 2181.
Judge, I'm going to need to get an evaluation done. So 224.
No objection.
All right, February 24th, Mr. Murphy, someone's going to come out and talk to you.
Thank you.
Okay.
Make sure you give me an order on that, Mr. Williams.
Well, Judge, we'll do it in-house and pay for it in-house. The court won't need to do an order.
Oh, okay. Talking about competency, right? Okay.
We'll also be looking at some other stuff, but
Oh, I got you
we have
then.
the ability to do it in-house.
I've got you. All right, go ahead.
Give me just 1 second, Judge. I'm just reviewing my notes.
This is Mr. Myers, John Myers. All right, 24 CF 663.
Judge, all right, looks like I discussed this with the state, and so I'm going to move to continue it.
And what needs to get done still, Mr. Williams?
Judge, most of it's trying to give the state a chance to, originally I was going to pass it until today to try to give the state a chance to talk to the, or else for us to reschedule depositions. There were witnesses that failed to appear. He's made an offer of agreeing to plead to one of the counts, but not the other counts. We've gotten witness statements from the two of the witnesses.
Are there more depositions?
Deposition, and it's all over whether or not it's a gun. The two primary witnesses are now saying that it wasn't a gun, that was an air compressor tool. We took the deposition of his roommate who testified that the hose for that air compressor is long enough to reach where this was involved. There's at least one civilian witness that didn't show up for deposition. The state's relying on to say that it was a gun.
Are you trying to reset depositions, or?
Yes, sir. We'll try one more time.
Okay. All right, 224, February 24th.
Thank you, Judge.
All right, thank you.
All right, sir.
Norris.
Who's covering Norris for the state?
I am, Your Honor.
This is Ronald Norris, 21 CF 2144.
Yes, sir. Judge, I think the primary reason for him to be here was we'd had some discussions about, well, originally for the stand your ground hearing, whether or not the medical examiner could appear by Zoom. He agreed to that. That's now been resolved. The ME's going to be here personally. And then there was also a question about whether or not he would stipulate to the person that had taken his DNA. I've talked with him about that. We're stipulating to that. The case has been around. We're trying to avoid another continuance.
Definitely think that's the right thing to do.
Absent a witness being available or something like that, we're not continuing.
So we've got the stand your ground hearing is tomorrow at
Yes, sir.
9. We're set for 4 hours, right?
Yes, sir.
Is the intent to go forward with a trial the week afterwards if need be?
Well,
Because you've talked about having a big trial coming up, and then you mentioned this. I just want to make sure I'm on the same page, because I don't think we ever talked about setting it for trial. I'm not saying we didn't. I'm just saying I don't recall that.
In discussions with Ms. Sandler, we're looking at the second week.
Okay.
So
How long do y'all
Monday-
think
that
it'll be?
Monday's a holiday. I think the plan is pick a jury on Tuesday, go to trial Wednesday and Thursday and Friday. We're anticipating a 3-day trial.
3 days. Okay. Anything different from you, Ms. Leone? I know you're covering, but,
Yeah, no, that's the understanding.
okay. Anything else that you're going to send me for tomorrow, Mr. Williams? Did you see Ms. Sandler had filed a 73-page response to your motion last week? I didn't see it till yesterday. I haven't started reading it yet.
I did, Judge. The response is actually shorter than that. That's the supporting documents that she attached.
I understand, but.
And I gave my client a copy of it yesterday.
Okay. So I just want to be able to read all of that today, so that
Yes,
when
sir.
we get here tomorrow, I'm ready to go.
She and I have talked, there may be 1 or 2 photographs, but by and large, tomorrow's going to be testimony-based.
All right, and then at this point, I'm not sure if I can guarantee I'll have a decision tomorrow.
Yes, sir.
Because I don't know what I'm going to hear yet, but I'll certainly have a decision by Friday when we come back for our jury review or trial management calendar or whatever we're calling it now.
Yes, sir.
But I just, again, that's why I want to have it all read ahead of time. If there's anything else, please send it to me as quickly as you can, so I can have it read before tomorrow morning.
Yes, sir.
All right, we'll see you back then, Mr. Norris.
Thank you, sir.
Thank you, Judge. Judge, we were able to obtain some information about the alleged victim, and one of Mr. Jones's case, the original, or the first case. I've instructed my secretary to provide that to the state, and then I'm going to try again to set his deposition.
State.
That's fine. Your Honor.
That's Ms. Leone.
Yes, no objection.
Jones, do you understand? He's trying to depose another witness. Mr. Jones? I've asked you a question. Okay, you kind of just. I understand.
I understand.
Okay. He's trying to depose another witness, so he's asking for a continuance in your case. Mr. Jones?
Oh, I thought you were talking to him.
I'm talking to you. That's the second time you've just kind of not responded. And I don't think you're trying to do anything offensive or anything to the court, but are you okay? Okay, I understand. All right, so what day are you asking us to set it, Mr. Williams?
Go ahead and set it off another docket. If we get it resolved earlier than that, and we may be after trying to take this gentleman's deposition. I don't know that he's gonna show.
All right, February 24th.
Thank you, Judge.
Thank you, Mr. Jones. Is that everybody, Steve?
Judge, we can approach briefly. Sure.